The meeting of the Courts of Justice Subcommittee on Criminal Law will come to order. I don't know to what degree anybody's been witnessing what goes on in this subcommittee, but one, we have a lot of people with conflicts presenting bills or on other committees. But I would also say that it's been my experience over the years that the level of conversation that you were hearing in the room is part of the work of the committee, as the technical details of solving the problem. We may understand the problem, but it's the way in which it's solved that is just absolutely critical, especially in criminal law. So I think good work has been being done. With that, I will buy pizza for just the committee, if we are still going into dinner. With that, I would like to start with an administrative matter first. We have already re-referred to the Committee on Health, HHS. We've already referred a similar bill by Delegate Obenshain, and we now wish to do the same thing with which was HB 449. And now we will ask for the same motion on HB 1542, sponsored by Munden King, having to do with child abuse neglect mandatory reporters. That re-referral, I believe, is a voice vote. Re-refer, I believe so. Yes.
Madam
so
Chair,
all those in motion?
I'll make a motion to re-refer HB 1542 to HHS.
Second.
It's been moved and seconded. As seeing no one wishing to speak, all those in favor say aye.
Aye.
Opposed? Thank you very much, Delegate Munden King, for appearing with us. I'm going to start from the top of the docket, at least for the first two or three. Delegate Gardner, actually, I had promised her, she's been waiting. Delegate Gardner, I'm going to jump down to HB 179, even though we've tried to group into the block 2 everything having to do with length of time involved in might be the penalty for a given crime. So if you would start with HB 179, which is about consecutive terms.
Thank you, Madam Chair. Members of the committee, HB 179 would allow judges to decide whether a person convicted of mandatory minimum convictions should serve those sentences concurrently or consecutive to sentences for other convictions. One of the most significant positions within our criminal justice system is the role of the judge, the official we charge with using wisdom, experience, and knowledge of the law to facilitate just results to criminal cases. Mandatory minimum sentences limits the discretion of judges by requiring the imposition of predetermined minimum sentence for certain offenses. Repealing these mandates allows judges to reconsider individual circumstances, such as the nature of the crime, the offender's criminal history, and other relevant factors when determining an appropriate sentence. This helps to ensure that sentences are proportional and that they are actually fair. Simply put, this bill will restore judicial discretion. Madam Chairman, this bill was placed at the request of Prison Fellowship, and I would like to yield my time to my expert to answer any questions and make a statement if allowed.
If your expert would come forward, do I see any requests to speak if you would like to also present the bill, and then we would ask questions.
Thank you, Madam Chair and members of the committee. So my name is Sammy Perez from Prison Fellowship, and I'd first just like to start by discussing a few of the merits of this bill. So first, I just want to talk about what the bill actually does, which is simply placing judicial discretion back into the hands of our appointed judges. What the bill does not do is it does not do anything substantively to mandatory minimum sentences. It does not reduce any mandatory minimum sentences, or it doesn't tie the hands of judges to be able to dole out a lengthy sentence and or a consecutive term if that's what's appropriate in that case. We actually believe that this bill will protect public safety as we typically will spend lots of money at incarcerated individuals for a very lengthy amount of time. And when we can take those dollars and actually reallocate them to spend them on public safety measures that will actually help to protect the community, we think that's a very wise use of our funds. I'd also just like to share just a personal story about how I've personally been impacted by this issue. So at the age of 11, I actually became a ward of the state here in Virginia. And that led to a life of crime for me. And at the age of 18, I was pulled over. There was a firearm that was found underneath my seat. Because I had been convicted of a violent charge as a youth, I was actually charged as a violent criminal who was in possession of a firearm. So this led to 2 mandatory minimum sentences. At my sentencing, the prosecution actually recommended that all of my time be run consecutively. So I was facing a total of 16 years for the 2 mandatory minimum charges, as well as charges for not being honest about my identity. Thankfully for me, the judge was actually able to utilize his discretion as it relates to my non-mandatory minimum charges and actually chose to run that portion of my sentence concurrently as compared to running it consecutively. As it relates to my mandatory minimum portion of my sentence, the judge actually looked at me during sentencing and told me, Mr. Perez, I'm giving you too much time, but there's nothing that I can do about it. So I just share this with you to really highlight the importance of allowing a judge to be able to utilize their discretion, because for me, it actually allowed me to be released a little bit earlier. I was able to come home and be the first person in my family to graduate from a 4-year college. I actually went on to pursue a master's degree and would have pursued a PhD had my wife not told me not to. So I will just yield my comments there.
Thank you, Madam Chairman.
Since that was in order of testimony, is there anyone else here to speak for the bill before I open it up to discussion and questions from the members?
Madam Chair, Rob Hogenclass with Justice Ford, Virginia. Mandatory minimums are bad policy. I understand this bill, what this bill does, and it's a meaningful step in the right direction, so we wholeheartedly support the bill. Thank you.
Thank you. Next person.
Lily Hetrick from the Legal Aid Justice Center, and we support this bill.
Sean Winetto speaking on behalf of the ACLU of Virginia. Prison fellowship is a tough act to follow, so I would say that we support the bill as well. Thank you.
Thank you. Anyone in the audience wishing to speak for the bill or against the bill? Please come forward if you are here to speak against the bill.
Good afternoon, Madam Chairman, many members of the committee. Marcus Elam, Corrections Operations Administrator for the Virginia Department of Corrections. We do strongly oppose this bill for specific reasons. This bill, we believe, because of our concern with the change in language for this bill, reduces the deterrence for inmates that are currently serving time if they were to escape from custody. On line 1174, specifically, the language that's being stricken indicates or states, which shall be served consecutively with any other sentence. We believe that allowing a judge to have discretion for being able to, for a sentence to be run concurrent when someone's been convicted of escape would pose a threat to public safety and really reduce the deterrence for someone who's already serving time. So for that reason, we do strongly oppose the bill. Thank you.
And I want to make sure that we're talking about that specific provision is the concern you have in the Department of Corrections, correct?
Madam Chair, yes.
Thank you.
Thank you.
Good afternoon, Madam Chair, members of the committee. Brandon Robleski, Senior Assistant Attorney General. The Attorney General opposes this bill. It's been the judgment of this body each time it has amended these criminal statutes on an individualized basis that these are such heinous acts or such dangerous acts that a mandatory minimum sentence should be run consecutively, though some of those being bringing a weapon on school property, raping a child, and producing child pornography. The Attorney General opposes the bill. Thank you.
Thank you. Seeing no one else in the audience online, we have two individuals who have registered to speak for the bill. Mr. Daniel Landsman.
Thank you, Chair. Daniel Landsman, Vice President of Policy for FAM. The evidence does not suggest that mandatory minimums, especially stacked mandatory minimums, are necessary or needed to reduce crime, and therefore we strongly support this bill.
Thank you. And next, Mr. Fatih.
Good afternoon, Madam Chair. Ramin Fatahi, Commonwealth's Attorney for the City of Norfolk, here on behalf of Virginia Progressive Prosecutors for Justice. We strongly support this bill. Thank you to Delegate Gardner for carrying it. We believe that the judges that the General Assembly picks should be able to make decisions based on the cases before them. Mandatory minimums make that difficult, if not impossible. A judge doesn't need a mandatory minimum to impose a heavy sentence. A judge can do that under the cases that are almost always the primary charges when mandatory minimums are present. These mandatories make it more difficult for us to make individualized assessments as prosecutors, and they bind judges' hands when they shouldn't be bound. We should trust our prosecutors and trust our judges. I would ask that the committee support the bill.
Thank you. Are there questions of the patron of counsel on the bill? Yes, Delegate Coulson.
I'm confused after the testimony about whether or not this is discretionary or if it's mandatory that they have to be served consecutively. Am I missing something?
Counsel, if you wish to answer.
Sorry, Chair.
Madam Chair, Delegate Coulson. So under current law, all sentences are consecutive unless otherwise ordered by the court. And so it is discretionary, but the default is going to be that they're still served consecutive. It just gives, the amendments would give the court in these cases the discretion to run them concurrent if they thought it was correct.
So Chair Watts, I have one follow-up question. I guess then if we're giving testimony, which by the way, I'm sorry if I'm heated, but I take offense when you just randomly toss like raping children and somehow we're not gonna make a discretionary judgment with our judges that we're not going to shorten that sentence. So throwing out these heinous crimes without it being tied to the rationale of this specific bill, which is that this is not, in my understanding, unless I'm hearing or misunderstanding something, this is not requiring us to make it so that they're going to, lose time. They're going to have to do it concurrently. They can't do it. So I'm just confused. So that's all. Thank you for the clarification. I appreciate that, and I would, I guess, like to make it known that no, this change would not make it so that child rapists are somehow not having to serve their time.
And seeing no other member on request to speak, I will, Delegate, well, let me follow up by saying I also want to clarify that this does not do away with any of the mandatory minimums. It just, we're mandating that from the legislative side. But we are saying that the judge can have discretion about whether it is concurrent or consecutive.
Yes, ma'am. It restores judicial discretion.
Yes.
Yeah, question for staff. Staff, I heard DOC say something about escapes, and I don't know what they were referencing in this bill. Do you recall what that was, or how that impacts this bill?
Madam Chair, Delegate Williams, the only reference to any felonies by prisoners is 53-1203, which is at the very end of the bill. And get to the end of the bill. For the violation, if the violations of these are escape, there is a mandatory minimum 1-year term of confinement, and then this is deleting the line that says which shall be served consecutively with any other sentence. And so that subdivision 1 of that bill is escape from a correctional facility. So it's not under the typical, we think about 182479.1 escape, but this version of escape.
Okay. Seeing no other requests to speak, we operate on motion.
Madam Chair, I move to report.
Second. It has been moved and seconded that we report HB 179. Please open the roll. Members, cast your... I'm sorry.
It's unless to be referred to appropriations if we act favorably. 179.
Really?
Yeah.
Okay, the motion of the recommendation of this subcommittee needs to be that we report and refer to appropriations.
So moved.
Okay. Please open the roll. Please cast your vote. HB 179 is recommended for reporting and refer to appropriations by a vote of 6-1.
Thank you, Madam Chair and members of the committee.
Thank you. And now I would like to return to the docket as it has been published since I see Delegate Reeser in the room. Delegate Reeser.
Good afternoon, Madam Chair and committee members. I have an amendment in the nature of a substitute.
I believe it's been distributed.
Yes, Madam Chair, members of the subcommittee, there's an amendment in nature of a substitute. It's been passed out in your packets. What this substitute does is very large. I'm not sure I'm going to explain it the best way. I will let the delegate do it, but it does break down the court-appointed counsel fee section into the differentiations between misdemeanor charges, felony charges, and juvenile cases, depending on which court someone is in, whether that be a district court or a circuit court.
Madam Chair, may I speak to the substitute?
Does I hear a motion?
Move the substitute.
Second.
All those in favor of adopting the substitute, say aye.
Aye.
Opposed? Proceed.
Thank you, Madam Chair, and thank you to your staff who worked with us very closely to make these substantive changes that occurred after consultation with the Virginia Supreme Court's Office of the Executive Secretary and the Virginia Indigent Defense Commission. The amendment to the original bill draft bases the proposed increases in the cap on fees more surgically. They're now based on the complexity of the charge and time needed for counsel to prepare a defense rather than the broader category title of violent felonies. The substitute carves out 11 charges such as involuntary manslaughter, malicious wounding, aggravated sexual battery, arson, and the like. And it also now includes juvenile cases in district and circuit courts that were inadvertently left out of the original draft.
Thank you. Are there any questions of the patron?
Madam Chair, may I speak to the bill as well?
Yes, please.
That was just the substitute. This body directed JLARC to review the Commonwealth system of attorneys who represent indigent defendants in criminal cases. And the very first JLARC recommendation to come out in that report was to increase the cap that currently exists in their compensation. HB 102 does exactly that. This bill establishes new statutory caps based on the updated case weights in the JLARC report from November of 2023. In other words, with the passage of this bill, Virginia will begin to more adequately compensate court-appointed lawyers for the time they need to prepare for complex matters. It's noteworthy, I believe, to add that Virginia is at or near the bottom of statutory caps across the nation and which in Virginia have not been adjusted since the year 2000. So that's the turn of the century. The Commonwealth's caps are substantially lower than our surrounding neighbors, including North Carolina, South Carolina, West Virginia, and Tennessee. For example, a misdemeanor in Virginia caps at only $120, while the cap in every other state mentioned is over $1,000. For a felony, the Virginia cap is roughly $1,200, while other jurisdictions have caps of upwards of $10,000. There will be a fiscal impact statement on this bill, and a placeholder budget amendment has been submitted. So together with the help of JLARC and the Virginia Indigent Defense Commission, who are here today, I'm happy to answer your questions and then offer some closing remarks.
Thank you. Are there any questions of the patron? Seeing no requests to speak, is there anyone here in the audience wishing to speak for HB 102?
Allison Powers from the Indigent Defense Commission. We want to thank Delegate Reeser for carrying the bill. And for once, I am able to say the Commission supports this. This has been long overdue.
Thank you.
And I'm happy to answer any technical questions about it as well.
Thank you.
Rob Hogan, for Justice Forward. We enthusiastically support this bill. Court-appointed attorneys across Virginia are not taking as many cases anymore. The numbers have been declining for years. It's because of the pittance that we pay them. We haven't updated this figure in over 25 years. It's long overdue, and I hope you support the bill. Thank you.
Thank you.
Thank you, Madam Chair, members of the committee. My name is Maisie Osteen. I'm from the Legal Aid Justice Center. And while we very much support this bill, it's incredibly important for indigent defense and the quality of representation across the state. We are really concerned about the cost being passed on to the individuals and their families. The way that the law is structured now, every dollar for dollar that is assessed will be assessed to the individual in court costs. And I think that it's really encouraging. West Virginia, they pay more and they don't pass on any costs. North Carolina, they pay more and they pass on a $5 cost. South Carolina, they pay more and they pass on a capped cost at $500. So we are very much in support and know that this is a needed, necessary change, but also just want us to move forward thinking about how we can ensure that it doesn't further entrench people in the criminal legal system as they need this required constitutional right. Thank you.
Thank you.
Chairwoman Watts and members of the committee, my name is Bethany Harrison. I'm the Commonwealth's attorney for the city of Lynchburg, here on behalf of the Virginia Association of Commonwealth Attorneys in support of this bill. Thank you.
Thank you.
Hi, Mary Ottenot, OTTINOT. I'm in support of this bill, but just like the was stated before, that it's been a long time coming. So we had a lot of, maybe shenanigans happening in our current system. So we got to think about that as we're now hopefully moving towards a better system with better people, accessible to, to better people. And I'm no shade against any attorneys in here, but I'm really hoping that this brings up the caliber of the type of attorneys that we can pull into the system that want to take on these type of cases. And when that happens, maybe take a look then also, how are we ensuring accountability for those attorneys that are court appointed? I know we have some things that are going to be going on with the Parent Advocacy Commission. That's going to be getting off the ground soon. It'll be doing some training there. I really hope that notion around training, that notion around standards is something that crosses over now that we're making this investment as far as money, that we also understand that we owe it to taxpayers to get our bang for our buck. Thank you.
Thank you. Is there anybody in the audience wishing to speak against 102? Seeing none online, I had 3 people signed up to speak for, but I only see Mr. Fadahi here. If you would proceed, and then I'll see if the other 2 are in the room.
Right. Thank you, Madam Chair. Ramin Fadahi, the Commonwealth's attorney for the city of Norfolk. I'm here on behalf of myself and the Commonwealth's attorneys for Prince William County and Charlottesville. This is an access to justice issue, but it's also a matter of it improves the integrity of our convictions. It helps everyone in the system to have high quality lawyers and enough lawyers to do the work and to help us serve justice. We appreciate Delegate Reesers bringing the bill.
Thank you. Seeing no one else online, is that correct? Thank you. Are there any questions, concerns before we take the vote? Delegate Hernandez.
Just a comment, Madam Chair, that I just want to thank the patron for bringing this legislation. I think compensation here has been long overdue for an increase, and I'm hoping also that it makes an immediate impact as well. And at the appropriate time, I would make a motion.
Okay. A motion is in order.
I move to report and refer to appropriations.
Second. It has been properly moved and seconded that we report and refer to appropriations. HB 102, please cast your vote. House Bill 102 reports and is referred to appropriations by a vote of 8-0. That is, we recommend and the full committee will so do.
Thank you, Madam Chair, members of the committee.
Thank you. The next bill that on our docket is HB 470. Delegate Martinez. We have heard this bill before. I believe there is a substitute that could be brought before us.
Yes, Madam Chair, members of the subcommittee, there is a new substitute. I'm trying to post it on LAS right now. What the substitute would do, it's been distributed to you all. On the first page, it does add in that new subdivision V regarding court-appointed, guardian ad litem or attorneys filing chins petitions. And then toward the back of the document, when we were having discussion regarding whether or not a parent could go around a intake officer who denied a petition, language has been added in this portion saying, creating a rebuttable presumption of probable cause that if a parent is the one asking for this chins petition, they should grant it, but that presumption can be overcome by a totality of the circumstances. And if so, the officer that refuses to file that petition shall provide written explanation to how that presumption was rebutted and provide information to the parent or guardian regarding any agency other than the court that can provide services.
Thank you.
Madam Chair?
A motion is in order on the substitute.
Move the substitute.
Is there any discussion? All those in favor say aye.
Aye.
Opposed? Yes, Delegate Martinez.
We have been working hard on this bill, and to tighten up some of the impacts, we have another amendment that's going to strike, I believe it's line 108 from there shall be to line 114 for the child. That would be stricken and replaced with this amendment. Sorry about the shortness of notification. I just got it a few minutes ago. Would be replaced it with, if the intake officer refuses the petition when sought by a parent or legal guardian, he shall be given a written explanation as to the reason for such refusal and to provide resources to the parent or legal guardian to other agencies other than the court.
Are there questions on the amendment? And you were just, if you could explain the amendment. Right. Council, are you ready to explain the amendment? Thank you.
Madam Chair, the amendment takes out the rebuttable presumption language and inserts instead that when the officer refuses a petition, that the intake officer has to give a written explanation to the parent because in order to basically get more accountability and transparency as to the reasons for the refusal, and there shall provide resources to the parent for other agencies other than the court. And that's actually part of the statute above that, where it says that one of the reasons it can be refused is because there is another agency available that can more effectively deal with the issues that the parent is having. And therefore, that now the intake officer is required to do that.
And Madam Chair, members of the subcommittee, if it makes it easier, it would just remove the sentence on line 108 through 111, and the sentence that then follows that would just be reworked to be in the proper format for grammar.
Thank you. Are there any questions now of the amendment before we move to add it? A motion is in order.
Move the amendment as reported by council.
All those in favor say aye.
Aye.
Okay, so we have a substitute as amended. Would you like to speak to it, or shall we just call for people who are in support of the bill with the substitute as amended?
Well, I would like that, but if the committee would like me to reiterate what we talked about last time, I'd be.
No, we have heard the bills, but I would like to have any testimony, anyone who is speaking for the bill, the substitute as amended, so that we are clear about how this plays out in the reality that the delegate is concerned about.
Thank you, Madam Chair, Delegate Martinez, and members. Sushila Varkey from Virginia Poverty Law Center. We worked with Delegate Martinez and staff to come up with this language, and we support it. It basically addresses some of the concerns you all had during testimony on Friday about overwhelming intake with parents' efforts to petition for chins. So I think what Mr. Mutnick and Mr. Hatcher described in the sub actually does that. It asks, as Steve Mutnick described, for transparency from the intake officer when refusing is happening, but it doesn't send parents directly to clerks. They still have to go through the intake office to ask for a chance. So Virginia Poverty Law Center supports the substitute. Thank you.
Is there anyone else speaking on the substitute as amended? Are there any questions? I don't see anyone online for 470. Are there questions or comments from the members? If not, we operate on motion.
I'd like to move to report with substitute as amended.
It has been moved and seconded that any discussion. Clerk, open the roll. So again, I'm double checking that we did this right. Thank you. HB 470 reports with substitute as amended by a vote of 7-1. Thank you. Thank you very much.
Madam Chair, Committee, for your indulgence.
Welcome to the General Assembly. The next bill before us then on the docket, and I see Delegate Coiner is here, that would be HB 653.
Thank you, Madam Chair. House Bill 653 cleans up current law by removing some offenses from the list of violent offenses in Code 17.1-805C. This bill does not substantively change any punishments, only the categorization as violent or nonviolent. The purpose of this legislation is to ensure that sentence enhancements are only applied to violent offenses. It also helps with future cleanup of the barrier crimes list. As background, Virginia's sentencing guidelines provide a judge with sentence recommendations based on historical practices, the nature of the current offense, and a defendant's criminal history. The guidelines also include enhancements that allow the judge to increase sentence lengths for violent offenses. I would note, if you look at the offenses we were removing, they do not meet the definition the FBI would use as a violent offense, which is an offense that is forceful or includes a threat of force. However, in Virginia, several offenses are categorized as violent that do not include force or a threat of force. So our bill, again, does not remove these as crimes. It simply takes away the classification as violent and ensures that there is proportional punishment for the crimes being committed. I'd be happy to answer any questions that the committee does have. This is part of, again, some of these are currently barrier crimes. The past few years, I've tried to tackle those issues. Other delegates are continuing to tackle them. We found a lot of argument over removing things that were violent versus nonviolent. So this is part of my effort in assisting with ensuring we're classifying offenses properly.
Thank you, Delegate Coiner. Are there, seeing no requests to speak, are there people in the audience who would like to speak for HB 653?
Good afternoon, Madam Chair, members of the committee. Sean Winetta speaking on behalf of the ACLU of Virginia. We appreciate this effort to clean up the bill. We do support it. There's certainly a lot more work to do, but we think this is actually a very good start. And there's a lot of things that are included in a violent crime statute right now. And I'll point to one that's actually even come up earlier today that I'm very familiar with, and that was the escape from prison charge in a crimes by prisoners 53.1-203 is classified in that violent crime statute. That's actually what I was charged with, and I actually simply walked out of a jail. There was no, my indictment specifically said without use of force or violence. So a lot of cleanup to do, and this is a good first step, and we really appreciate the bill coming forward. Hope you'll support it.
Thank you.
Good afternoon again, Sammy Perez from Prison Fellowship, and we support this bill because we believe it protects proportional punishment. I'd love to just take a moment to briefly share with you another portion of my story. I feel like you're all getting a chance to get to know me a little bit intimately, and hope that maybe one day I can come and share some positive things that I've done. But unfortunately for me, at the age of 15, I actually was charged with breaking and entering. I walked into a community member's home, I took the keys off the wall, and I drove away with their vehicle. As I shared earlier, that ended up causing me, because that charge happened at night, it was considered violent. And what that did is that caused me to receive a sentencing enhancement for the mandatory minimum charges at 18, which ended in a 10-year sentence. I want to be very clear that I take full responsibility for my behavior and the bad decisions that I made, but I do think it's important to kind of note the circumstances of the crime that was actually committed, and that there really wasn't any force or violent sort of actions involved. In fact, if I had committed that crime about 2 hours earlier, it would not have been a violent crime because it would have been during the day. So I just share all of that to say that accurately classifying offenses as either violent or nonviolent is extremely important and really can impact the lives of individuals like myself who have the potential to be released and come out into our community and be productive members of society. So with that said, I just ask that you all support the bill.
Thank you.
Is this one going to require?
I will double check. Yeah. Is there anyone here speaking against the bill 653? I have no one online. I am double checking before I call for a motion to make sure. I do not see that it has been asked to be re-referred, so a motion is in order.
Move to report.
Is there a second? Second. All those, please open the roll. All those in favor of recommending reporting HB 653, please cast your vote. HB 653 passes by a vote of 7, reporting by a vote of 7 to 3. I'll get it right. By a vote of 7 to 1. Thank you. The next bill on the docket is Delegate Maldonado's 697.
Good afternoon, Madam Chair, members of the committee. I do have a substitute.
Madam Chair, members of the subcommittee, this substitute should be posted online and it is at your desks. This substitute has a lot changed in it different. I'll let the delegate explain the reasons for that, and there will be further amendments to this if the subcommittee would adopt the substitute at the appropriate time.
Thank you. Is there a motion on the substitute?
Move the substitute.
It's been, all those in favor say aye. Thank you. Opposed? Delegate Maldonado, if you would explain the substitute and the bill.
Yes, thank you. There also is an amendment to the substitute. Should I explain the substitute first and then?
If it clarify your presentation, that would be excellent. Thank you.
Sure. So generally, the substitute really clarifies through the inclusion of certain definitions and also penalties for how the consequences will be for using synthetic media, or what is more commonly known as deepfakes, across a couple of different areas: defamation, fraud, slander, and libel. I would like to share the amendment and then speak to the bill generally in a cohesive unit. I think that might be easier
Council,
to understand.
if you'd report the amendment.
Madam Chair, these will be presented by the delegate. She will give us the line numbers on what's being removed. I think they are just strikes.
Correct. Yes, Madam Chair.
Is there a motion on the amendment?
Move the amendment.
All those in favor say aye.
Aye.
Opposed? Proceed.
Thank you, Madam Chair. This was just an oversight that this didn't get picked up. It was picked up in another section, and so we realized we didn't catch it here. In the end of line 44, beginning with the word "and," striking that through the comma that follows the word "with" on line 45. So that sentence would be, "Such punishment shall be separate and apart from any punishment received for the commission of the primary criminal offense."
This issue has come up. All those in favor of the additional amendment as reported, say aye. Aye. Second. I should have said, may I hear a motion to move the amendment? So moved. It is seconded. Now, all those in favor say aye.
Aye.
Opposed? Please proceed.
Thank you, Madam Chair. So I want to just say a couple of things. Many of us have seen over the last couple of years the increase in the use and the creation of synthetic media, which we often refer to as deepfakes. Many jurisdictions around the nation have instituted or passed laws around deepfakes, particularly in two critical areas: revenge porn and political campaigns. We have taken a different approach because we think that as this technology grows, as it becomes more sophisticated, the use of synthetic media for nefarious purposes is going to really be a horizontal and not a vertical. So in this instance, what we're doing here is proposing that we provide language that strengthens up our code in 3 areas: defamation, fraud, and to slander, libel sections. And the reason why we think the deepfake or synthetic language is appropriate to come here is, again, because we believe that we're seeing examples, growing examples of where this is happening outside of the 2 areas of revenge porn and political campaigning. What is very clear is that in some cases, it is uncertain whether political speech would be exempted from these areas of the code. What I will suggest is that with this kind of technology, the courts are not well settled. It is becoming much more sophisticated, and even in the cases that are settled, there is division. There's not uniformity in some of the case law. So what we do here also is for the instances for slander and libel, there is included a Class 3 misdemeanor, and that means of an imposition of a fine of not more than $500. And for the more serious cases that really include fraud, there's a Class 1 misdemeanor where the courts can decide whether they have the options of up to 12 months in jail, up to $2,500 fine, or both. And this gives discretion. The amendment that I provided is meant to allow the courts to use discretion given the totality of the circumstances, and we want to make sure that folks can do that. In many areas where we look at the use of synthetic media, they happen to be in cases where people are feeling like they're being defamed. There's a fraudulent act happening. We've seen examples of robocalls. We've seen examples of videos and other places where synthetic media is being used to confuse people, to provide and disseminate misinformation. And then also slander and libel. Many of the times where you see the use of this kind of media, it ends up being in one of these categories. And so we think it is best that we do a horizontal and rather than just carve it out. The code already does have something related to revenge porn, but this makes it very clear that when you use these things in the commission of one of these crimes, that it does elevate to proper consequences. So I will pause there, and I'm happy to answer any questions, and I believe we may have some folks in the room that may want to speak to the bill as well.
Thank you very much, Delegate Maldonado. Are there any requests to speak? Seeing none. Oh, I'm sorry, it wasn't on the board. Yes, Delegate Hernandez.
Thank you, Madam Chair. Just a question for the patrons. So we talked a little bit about the conflicting case law here. Did you mean that sort of across the country, courts are all over the place, or Virginia courts specifically? I was just curious if this has come up in our courts.
Thank you, Madam Chair. I would say to the delegate that the case law I'm talking about that's conflicting is whether or not the slander, defamation, fraud, libel provisions of a law would cover political speech. And because there are different cases across the country that land on either side of that, depending on the circumstances. What I will say, though, is that no one has really adjudicated carefully what happens when we have this rise and increase in the use and integration of synthetic media. I believe that there's going to be a whole slew of case law that's going to have to address that issue. And what we are trying to do for Virginia is to help us get ahead of the curve and not treat it as a siloed issue in just political campaigns and revenge porn, but look at it holistically so that we have a framework in place.
Thank you. Seeing no other requests to speak, anyone speaking here in the audience, speaking in favor of House Bill 697?
Good afternoon, Madam Chair, committee members. Brandon Robleski, Senior Assistant Attorney General. The Attorney General definitely shares the committee and the delegates' concern about synthetic media. With our original jurisdiction in child pornography cases, the Attorney General is seeing a marked increase in morphed child pornography. And there's another federal circuit split on whether morphed child pornography or artificially generated child pornography is protected by the First Amendment. So that's an emerging issue that we look forward to discussing in the work group that this bill convenes, and we look forward to working with the delegate and the General Assembly on this pressing issue. Thank you.
Thank you. Anyone else speaking for? And if there's anyone else, please come up and stand in line so I know how many we will be hearing from. Please.
Hi, my name is Mary Atanan. I'd just like to say I'm for this bill in more ways than I could even imagine, and I think so much that we have Delegate Maldonado that has her finger on these issues that are thinking so far ahead than we could even imagine, because we're really far behind in Virginia. So yes, I'm for this bill.
Thank you. Is there anyone speaking against the bill? Seeing no one online, are there other questions or comments? Not, and we operate on motion. And this has been a substitute as amended.
Move to report the substitute as amended.
Okay, it has been moved and seconded that we recommend that HB 697 be reported with substitute as amended. Please open the roll. Members, cast your vote. Okay. HB 697 reports with substitute as amended by a vote of 8-0. Thank you very much.
Madam Chair. Thank you, Madam Chair, and members of the committee.
The next bill on the docket is Delegate Shin, HB 926.
Thank you, Madam Chair. Good afternoon. I've been before y'all a lot this past couple of weeks. I got to stop writing bills that come to courts. I feel like council agrees with me. I believe there was a substitute that was prepared.
Yes, Madam Chair, members of the subcommittee, the substitute has been distributed to you and it is posted online. This does a couple different things, so I'm going to walk through it. This no longer strikes out any language regarding the intent on subsection A. How was I wrong? This still adds in the new Romanet A3, but removes language regarding sensuality. This bill also now adds a legislative fix, clarity fix, to the statute of limitations under 19.2-8 for the violation of 18.2-386.1, clarifying that the statute of limitations for that offense, for a misdemeanor violation of that offense, will be 10 years. And then it clarifies from the date the victim discovers the offense. And that would be for a violation of 18.2-386.1 and a violation of 18.2-386.2, both misdemeanor violations.
Thank you. Are there any questions of the amendment as reported? Motions in order?
Move the amendment as reported by council.
Second. All those in favor say aye.
Aye.
Please proceed.
Thank you, Madam Chair. As amended, House Bill 926 does two things. It expands the current categories of images that are unlawful to disseminate or sell to include videographic or still images that depict another person who is in a state of undress, even if it does not expose the genitals, pubic area, buttocks, or female breasts, but the videographic or still image is still sexual in nature. It also extends the statute of limitations from 5 to 10 years for the unlawful creation of the image of another, but it also establishes a 10-year statute of limitations for the date of discovery for the unlawful dissemination of such images. The bill starts the statute of limitations for both offenses at the time the victim discovers that the offense has occurred, whereas current law only starts the statute of limitations for the offense of unlawful creation of the image. I've been working directly with victims on this bill, and one comes to mind in particular because what happened to her was that many years after her ex-partner had created a photo of her without her knowledge or consent, he was holding it over her head and using it to intimidate and bully her. The statute of limitations had passed already for her to be able to bring it back and press any charges against him, and so the reason she brought it to me and to other legislators is that she hated this idea that her ex-partner would be able to wield and hold this power over her because he had explicit images that she did not consent to being taken or being disseminated to, and was threatening to do so. And so that's how this started. The Virginia General Assembly started this work a few years ago in talking about non-consensual pornography and the non-consensual dissemination of pornographic and intimate images. And I think this is just another step in the direction of making sure that we're protecting victims of non-consensual pornography. And all too often, victims don't even know that their personal images will have been disseminated. And I think the extension of the statute of limitation makes a lot of sense, that a person can still press charges after they discover that that has happened to them.
Thank you, Delegate Shin. Delegate Williams?
Yeah, a question for the patron.
Mm-hmm.
I was wondering why you went from a Class 4 felony back down to a Class 1 misdemeanor.
Madam Chair, I'd say thank you to the patron, or thank you to Delegate for that question, because that is an important question. And we thought that leaving it right now as a misdemeanor allows us not to mess too much up with the existing statutes and code, and allows us to sort of find a amenable and feasible path forward.
Are there any other questions? If not, is there anyone in the audience here to speak for HB 926? Is there anyone? Yes, and again, if all who are speaking for could come forward, that would be very helpful.
Good afternoon, Madam Chair, members of the subcommittee. My name is Catherine Ford with the Virginia Victim Assistance Network. We are the membership organization of victim witness advocates who work with any victim of any crime, and we support this bill. Increasingly, relationships include consensually exchanging intimate images, which may later become fodder for humiliating cyber attacks. Often these images spread quickly and uncontrollably. The effect of this distribution is a violation of the depicted person's privacy and trust. Distribution is intended to be embarrassing, humiliating, harassing, and degrading. And these effects are real regardless of what the images depict, which is what House Bill 926 addresses. Further, extending the statute of limitations builds in needed time for victims who discover the transgression later, and we hope you support the bill.
Thank you.
Madam Chair, members of the subcommittee, Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. We associate ourselves with the prior comments and do support this bill and hope you'll pass it. Thank you.
Thank you. Anyone speaking against the bill, please come forward. Seeing none, and I see no one online. Council, is there anything that we should be aware of before we take the vote? No?
No, Madam Chair.
Okay.
Madam Chair.
Yes, Delegate Hernandez.
Move to report the bill.
Delegate Williams, did you wish to speak before
I'm
we?
sorry. No, thank you.
Okay, thank you. It has been moved and seconded to report.
With the substitute.
I'm sorry. To report HB 62926 with substitute. And was the substitute amended? No. Okay. With substitute. Open the roll. Members, please cast your vote. HB 926 reports with substitute by a vote of 8-0. Thank you very much, Delegate Shin. The next one is Delegate Simon. I think he's still in Civil Sub. The next one is HB 1443, Delegate Davis.
Thank you, Madam Chair, and ladies and gentlemen of the subcommittee. I would like to speak to House Bill 1443, and Madam Chair, I'd move to substitute.
Madam Chair, members of the subcommittee, if you remember discussion last week, there was a substitute that was prepared based on that discussion. The substitute's been distributed to you and posted online. What this substitute now does is it's one code section, no subsections at all, that simply says, no person shall knowingly and intentionally contact with the intent to harass or intimidate a juror after a jury trial. A violation of this section is a Class 1 misdemeanor.
Thank you. Any questions on the substitute? On the amendment? Okay, substitute, of course, it's crim sub. We always do substitutes. Second. It's been moved and seconded. All in favor say aye. Aye. Opposed? Please proceed on the substitute.
Madam Chair, the purpose of this bill, as I've mentioned before, is to keep our jury system working like it's supposed to. We don't want our jurors to be intimidated or harassed after they've rendered a verdict. So that's the purpose of this, and we would ask that you report it to the full committee.
Okay. Anybody here speaking for HB 1443, please come forward. Anyone speaking in opposition? Seeing no one online, are there any other questions or concerns? Committee ready for the vote? A motion? Oh, Council, did you have anything to share?
Madam Chair, I just keep going back to, and I'm sort of thinking out loud, the way, and this is one of your specialties, Madam Chair, so I may ask for your help in this, but the way this reads to me, that if you knowingly and intentionally contact a juror with the intent to harass or intimidate after a jury trial, it doesn't have to necessarily be as written about the jury trial. And I think there's language we can put in there to do it. We had this discussion yesterday, and I'm just still having the discussion in my head about, do we need language that says, about the jury trial or in touching the service of the jury service, so that we don't create this new crime of just, you had to be a juror, I talked to you, I harass you after you sat as a juror in a jury trial, and I've now committed a crime I didn't even know I was committing because I was harassing you about something completely different.
Again, so you are comfortable with the intent to harass or intimidate refers to the jurors having served as a juror, not just random.
I think we need to. Madam Chair, I believe if we added language that said contact regarding such juror's service, or somewhere in the bill we put those words, regarding such juror's service as a juror, we would fix any potential issues. Because I think that's the point of the bill, is contacting them about their jury service.
Okay. A motion would, I know for myself, I am comfortable that further tightens down the problem that you were addressing. Is there a motion?
Madam Chair.
Pardon?
Madam Chair.
Oh, yes, I'm sorry. Thank you, Delegate.
I'd like to ask the delegate if he's would be interested in a friendly amendment.
Absolutely.
And I would so move the amendment based. Sorry.
Let me just recognize Delegate Hernandez, who had actually been before you. Go ahead, Delegate.
Thank you, Madam Chair. Just a question for council. So I think we talked about this a little bit last time we met, but we already have laws preventing harassment. What does this add that wouldn't be covered under those laws already?
Our laws actually prevent harassment over the telephone or over the internet. There's really no law about physically harassing somebody or in their physical presence harassing somebody in Virginia. So this touches that. This would be, there's obstruction, but that I think would apply during or prior to jury service. But at post-jury, I don't think it applies to it because it doesn't impede their ability to be on a jury once the jury's done. So we do have the telephone. So if they called up and harassed them, we do have a crime that covers that. But I don't believe we have an in-person harassment for this purpose.
So just to make sure, so Madam Chair, so we would have no tool really under current law in an instance like this to use criminal law and hold someone accountable. That's why this bill is before us.
And Madam Chair, I think I would agree with, unless there's certain factual situations where other charges could be brought, but a simple verbal harassment of a juror about their jury service would not be covered under current law.
Thank you. A motion is in order on the amendment to the substitute.
I would like to move that. Madam Chair, I'd like to move that we amend the substitute based on what staff has as reported.
Second. All those in favor of amending the substitute as reported, please say aye. Aye. Opposed? Okay. Now the substitute as amended is before us. We've already called on witnesses, so a motion is in order.
I move to report.
Second. It's been moved and seconded that House Bill 1443 be the substitute for be reported as amended. Please open the roll. Please cast your vote. Okay. HB 1443 reports with substitute as amended by a vote of 7-0. Thank you very much, Delegate Davis. And now, next on the agenda, Delegate Munden King's just making sure we all know that one has been re-referred. Therefore, we're now into Block 2, and that would be HB 45, Delegate Siebold.
Thank you, Madam Chair and members of the subcommittee. HB 45 is a technical bill that simply clarifies the original legislative intent of the expanded earned sentence credit, otherwise known as ESC, which passed in 2020 to incentivize good behavior and rehabilitation for people who are incarcerated. That original legislation indicated that a person who qualified for ESC was eligible for the entire sentence. However, the current policy, which is now interpreted by the Office of the Attorney General, limits the amount of credits that can be earned during pretrial detention. This conflicts with the legislative intent. While those who have been convicted can earn full credits, those in pretrial detention are denied this opportunity despite participating in similar rehabilitation programs. This disparity not only undermines this program's mission, but imposes a substantial financial burden on the Commonwealth. I hope it is the will of the committee to report this bill. Thank you.
Are there any questions of the patron? And this is as introduced. No amendments, no substitutes. Thank you.
Let's dirty it up.
Seeing no one request to speak, anyone speaking in favor of HB 45, please come to the microphone.
Good afternoon, members of the committee. Sean Winetto speaking on behalf of the ACLU of Virginia. We do support this bill. One of the things sort of actually that's in the code is that the court does give people credit for pretrial detention. As the delegate said, the patron of the bill said that they are participating in programs while they are in the jail, as well as when they do actually go to the Department of Corrections. So we're just asking for equitable time to be credited to them as they earn it. Again, it is the earned sentence credit program, so this is not something that's simply given to you. And this legislation was really carefully crafted by this committee in 2020 during the special session. So we ask that you'd make sure that the work to make sure that the Department of Corrections gets in line with the legislative intent that you had 4 years ago. Thank you.
Thank you.
Good afternoon, Chair Watson Committee. Sheba Williams with No Left Turns. I don't think I need to add any more. We support the bill. Thank you.
Thank you.
Marian Kramer from Virginia Justice Alliance, and we support the bill as well.
Thank you.
Taj Manheft from the Humanization Project. We support the bill for all the aforementioned reasons. And just to reemphasize, this is simply putting policy to match the legislative intent, which has not been enacted currently.
Thank you.
Thank you.
Ben Knotts, Americans for Prosperity. We support the bill. We think it's important to create incentives for folks to change before they get out as opposed to hope they change when they get out. So we think this is a good policy. Thank you.
Thank you. Is there anyone here speaking against the bill? Please come to the microphone.
Good afternoon, Madam Chair. Brandon Robleski, Senior Assistant Attorney General. The Attorney General respectfully opposes the bill. Thank you.
Thank you.
Madam Chair, could I ask a
Yes,
question?
please.
Could I ask a question of you? I'd love a little bit more information, Madam Chair, if I could ask as to, I guess, your opposition, the rationale for your opposition, but more so if the case being made is that the intent of the legislation was for, the original legislation was, it needs to be clarified with this bill. Can you explain why the legislative intent of that policy isn't being executed in the way that the original bill was drafted?
Madam Chair, Delegate Delaney, if I could try to restate your question, are you getting at some of the recent Supreme Court decisions regarding the program? I apologize.
Well, Madam Chair, my question is, you know, this legislation before us today is being presented as clarifying language to say the intent of the original bill should look like this, this implementation. And it hasn't been implemented in the way that the legislature intended at the original passage of the bill. So this language is now being proposed in order to make it abundantly clear that this was in fact the intent of the original policy. So I guess my question is, was there confusion over what the intent is? Is there another reason why the policy that we enacted originally isn't being fulfilled in the way it was written, in the way that it was passed into law?
Madam Chair, Delegate Delaney, the Attorney General was not in office when this bill took place, but the Attorney General disagrees generally with the policy of the enhanced earned sentence credit system and does not support any expansion of it. Thank you.
Thank you. I have 5 people who have signed up to speak online. As I recognize you, if you could be equally brief as those who are here, and if your comments have been covered, please refer to them, and if you can add something new, we'll appreciate it. The first one who signed up is Mrs. Kimberly Jenkins Snodgrass. Next one is Francis Ross, followed by Mr. Fahy. Francis?
Madam Chair, good afternoon, and members of the committee. I just want to say that we support this bill and just want to reiterate that I was there when the other advocates were drafting the bill and when senators and delegates who are no longer in office were working for this bill, and this is the way that everybody presumed it to be. And just because some people don't like it, I just don't think this is fair. And this should clean it up and make it the way it was meant to be. Thank you for your support.
Thank you. Mr. Fahy, followed by Charles Muir. I'm sorry, followed by Kenneth Hunter. Please proceed, Mr. Fahy.
Thank you, Madam Chair. Ramin Fatahi here for Virginia Progressive Prosecutors for Justice. Everybody's covered the landscape, but we wanted to let you know that we prosecutors believe that this is both good policy and fair too.
Thank you. And Mr. Hunter, followed by Mr. Muir.
Yes, thank you, Madam Chair. My name is Kenneth Hunter. I'm speaking on behalf of the Virginia Justice Alliance, and we support this bill, just giving an opportunity for individuals to earn sentence credits by pursuing aggressive rehabilitation. So I think it just works in the favor of the community. Thank you.
Thank you. And finally, Mr. Muir.
Thank you, Madam Chair. Chuck Mayer, representing Julian, a civil and human rights firm. We strongly support the bill for all the reasons previously stated, but I would like to reemphasize that this bill would neither expand the earned sentence credit program nor create any additional releases. It would merely align existing policy with the legislative intent behind the bill. Thank you so much for your time.
Thank you. Seeing no one else online who has signed up to speak, are there any questions?
Madam Chair?
Yes, you have the last word, absolutely.
Would you mind if I respond to the Attorney General's office? Just want to clarify that we are not here to legislate this bill. This is law, and it was decided in 2020. And the Attorney General's office can't just disagree with a law and not believe in the policy that was created by this body and decide not to enact the law. I don't have a law degree, but I'm pretty sure that is not legal. And he should, if the intent of this bill, if the intent of the 2020 bill was to include all time served, then that needs to be enacted. So those are my thoughts.
Thank you. Are there any, seeing no one on the panel requesting to speak, a motion is in order.
Move to report.
Second. It's been moved and seconded that HB 45 be reported. Please open the roll. Members, cast your vote. Okay. The HB 45 reports on a vote of 7-0. Thank you very much, Delegate Siebel.
Thank you. Thank you, members of the committee.
All right, next on the agenda, we have heard HB 179. I'm going to skip 77 out of courtesy. In fact, out of courtesy, I'm going to turn, if you are ready, Delegate Davis, since you are not on the committee, you may proceed. And then we'll follow by Delegate McClure, who is also not on the committee.
Thank you, Madam Clerk. I would like to speak to House Bill 849. And the purpose of this bill, I'll give you an example. So when someone's convicted of a felony offense, they're put on probation, and as a result of being on probation, they have certain rules they have to follow. One is not failing a drug test. And so if they do, then there's certain others, technical violations other than drug tests, but that's the most frequently one I see in my practice. But if they, the current law is first 2 technical violations, that we're tying our judges' hands and they cannot sentence them to any type of jail time. We have to have some type of deterrent for this behavior. That was mentioned earlier during House Bill 179 that we need to give the judges discretion, and that was considering reducing a sentence or running the mandatory sentence concurrent. So I think we should give the judges the same discretion to give someone more time if they need it. Now, I have limited that time in my bill on the first technical violation to 30 days and the second technical violation to 90 days. I'll be happy to answer any questions.
Thank you. Are there any questions of the members of the patron? All right. Is there anyone here speaking for HB 849?
Madam Chair, Brandon Robleski on behalf of the Attorney General. This bill is about restoring discretion to our circuit judges. There's currently a mandatory maximum sentence of 0 days in place for contempt of a court order, and we are asking the body to restore discretion to our judges to impose the sentence they believe appropriate in probation violations. Thank you.
Thank you. Anyone here speaking against 849? Please come to the microphone.
Madam Chair, members of the subcommittee, Rob Hogan, Class for Justice Forward, Virginia. And we supported the Speaker's bill several years ago to limit the amount of time that someone could receive for a technical probation violation. At the time that bill was passed, the median sentence for a technical violation of probation was 6 months. So for someone failing a drug test, someone who's in recovery failing a drug test, they would go in front of a judge and receive a median sentence of 6 months on the very first time that happened. We know for people in recovery that that's what happens when you're in recovery. We can expect that, and punishing someone for 6 months doesn't accomplish anything. Showing up late for an appointment with a probation officer, these are the sorts of technical violations that this body made a decision to limit the amount of jail time to 0 days for a first violation and 14 days for a second violation. After that, the judge can impose whatever remaining suspended sentence there is. So we'd ask that this body not support this bill. Thank you.
Thank you.
Good afternoon, Madam Chair and committee. December 21st, 2016, a friend of mine was incarcerated in Richmond City Jail, and he died on the toilet in the infirmary because of his substance use disorder. Mandating jail time for a technical violation, which is not a new crime, does not only put people's lives at risk. There can be an option to give support and resources for people who are in active use, but we also are looking at, in the community, losing housing, access to family. We're talking about losing the 14 days of income when a person may have a job, they may lose that job. So for those reasons, I encourage you all to look at alternatives to incarceration as a means for treating society's problems. Thank you.
Thank you.
Good afternoon, Madam Chair, members of the board. My name is Sincere Allah. I am a state organizer for Reform Alliance, and we oppose this bill. Thank you.
Thank you. I am looking online. We have no one who has signed up to speak online. Are there questions? I just wanted to clarify, was there a specific, I thought there was a specific court ruling on this area. Counsel, am I mistaken?
Madam Chair, if you wouldn't mind clarifying, court ruling on which aspect of the proposed bill before you?
All right, thank you. We operate on motion? I'm sorry. I did not look at the request to speak. Delegate Coulson. Wouldn't be the first time.
Madam Chair, addressing the delegate, it's interesting. I have research in front of me. It was not in relation to your bill. It's actually in relation to my bill. Otherwise, I would have tried to give you a heads up. But I'm just curious your thoughts on the fact that prior to us revoking this being able to put incarceration as even on the first technical violation, there was a study by the Virginia Department of Corrections that indicated that approximately half of all new court commitments to state custody were as a result of violation of probation. So not the crime, the violation of the probation. And I guess I'm curious your thoughts about that and why you think this is necessary to increase incarceration to that level. And two, I just want to make it clear, maybe for myself, that there are deterrents in place from committing technical violations. You can get an extension of your probation period, and you can, in fact, get, you can, correct me if I'm wrong, can you be incarcerated after enough technical violations? That part I'm not sure of. But yes.
Yeah.
Yes,
Madam
so there
Chair.
are deterrents. So I guess my question is, why do you think it's necessary to have the deterrent at the first one when it's not backed by research and it has a huge cost and increases incarceration by that kind of level? Just what do you have to say to that?
People need to have consequences for their action. They've already committed a felony. They've been sentenced to time, but majority of it's suspended. So I think we got to have a deterrent to deter them. I have many clients, as soon as they get released, they go out. They know they won't go to jail. So they're just going back, hanging out with the same people, using drugs. And this could protect them, save their life, keep them from overdosing. I've had many, many clients die of overdoses. So this, if they're in jail, theoretically, they should not be able to get the illegal drugs, although I've had a client or two pass away in jail. So, but it would, they need to have consequences when you're on probation. You need to follow the rules. So that's my reasoning on that.
Thank you, Delegate Davis. We operate on motion.
Move the report.
Substitute motion.
Please.
Move to lay the bill on the table.
Second.
Okay. The motion to lay on the table is not debatable. Please open the roll. HB 849 is tabled by a vote of 5-2. Thank you, Delegate Davis. All right. The next one on the docket, who is not on the committee, would be HB 1252. Delegate McClure.
Yes, Madam Chair, members of the subcommittee, HB 1252 closes a loophole in our current probation law that has resulted in increased jail time for nonviolent technical violations. While on probation, something as minor as oversleeping and missing an appointment with a probation officer is considered a technical violation. In 2021, as it was mentioned, we passed HB 2038 carried by the Speaker, which was a sensible probation reform bill intended to ensure that multiple technical violations arising from a single incident would be considered together during the revocation hearing with a maximum sentence of 14 days total. However, some judges have skirted the law by holding separate hearings for each technical violation included in a single violation report, enabling them to impose a sentence of 14 days for each violation. Another problem is that people are being held in custody awaiting their revocation hearing for longer than the maximum sentence than they could receive. Holding people in jail for months or even years on nonviolent technical violations does not improve public safety. We are keeping folks tethered to the court system and unable to move forward with their lives well after they have paid their debt to society. HB 1252 requires the court to consider all technical violations that occurred prior to the revocation hearing at the same time. This bill also requires the court hearing to hold hearings within 14 days, or the person awaiting the hearing must be admitted to bail. HB 1252 upholds the spirit of the 2021 probation reform bill and reins in those who seek to undermine it. Madam Chair, members of the subcommittee, it is my hope that you will vote favorably in support of HB 1252.
Thank you. Delegate Williams.
Yes, ma'am. Question for the patron.
Proceed.
We talked about this a little bit, and staff can help me with this. My only concern on this bill is, when can a defense attorney ask for a hearing to prove the clearing, when can the Commonwealth prove the clear and convincing piece? That's what I don't know where that particular piece comes in. Just when can that happen? Staff.
Madam Chair, Delegate Williams, so under the amendments in the bill, I would envision that someone would be picked up, they would be arraigned on their probation violation, the judge could make a determination as to bond at that point. If they hold the person without bond, then this would require them to set a hearing date within 14 days. If the case is not adjudicated within 14 days, then it would be at that hearing date where I guess it would likely be the Commonwealth asking for a continuance motion, where the judge would have to make that determination of release as per the statute, or there's a risk. And so it would be at that first hearing date set within the 14 days.
Do you need a follow-up?
The adjudication.
Adjudication.
I'll talk to him separately.
All right. Are there any other, I see no one else requesting to speak. Are there members of the audience to speak for HB 1252? Please come to the microphone.
Yes, Madam Chair, Rob Hogan-Class from Justice Forward, Virginia. I think what Mr. Mutnick said is correct. I think also in many situations, the court may not set that extra hearing, and then it's going to be incumbent on the defense attorney to set a bail hearing, and at that point, the prosecution would have to prove the clear and convincing. We thank the delegate for bringing the bill. This is the bill that was forced by a court decision. The Court of Appeals upheld the judge's decision, circuit court judge's decision, to go back into chambers for 5 minutes and then come back out and hold a separate hearing on each of the 6 technical violations that a person had committed that were all in the same violation report. So this would close that loophole, and nothing to add to the delegate's presentation. Thank you.
Thank you. Is there anyone in the audience speaking against? Please come to the microphone.
Good afternoon. My name is Ryan Mahaffey. I'm the Commonwealth's attorney for Spotsylvania County. Respectfully, I'd like to speak in opposition and caution the General Assembly from enacting legislation that makes probation unworkable. I've been a prosecutor for 12 years, Spotsylvania, and I know our judges are very frustrated with the way that probation currently works. It's very difficult to navigate. It's a labyrinth of different legislation, different decisions, and as I didn't intend to speak on this particular bill coming in, but I would point out to the delegates here today that giving discretion to judges was persuasively urged on this body by Delegate Gardner in regards to reducing sentences and running mandatory minimums concurrently. It was very not persuasive when offered as a rationale for giving discretion to judges in allowing very modest amounts of time on probation violations, 30 days for a first technical, 60 days for a second technical. And one of the arguments that was made was that it's, just the first technical person popped positive. But the reality of the matter is when a probation violation comes before the court, as this bill addresses, it's many, many technical violations. The probation officer has already become so frustrated with that person that they issued a major violation report. And then if it is adjudicated that they're in violation of the terms of probation, they're released back to probation and they just engage in the same behavior many, many times because they have learned, as the other delegate relayed to this body, that there really is no consequence until there's a first major violation report. And that could last 6 months, routinely last 6 months. And so if this body is using probation as a rehabilitative tool, we need to give the tools to the probation officers and to the judges that they can use to try and rehabilitate those people. Otherwise, misbehavior will not be corrected, and that is an injustice to the person that needs to have that attention. Thank you.
Thank you. Speaking, I have online, I have Kimberly Jenkins-Snodgrass, who has requested to speak. She is not online. Excuse me, Delegate McClure, you have your final word.
Yeah, I would just like to see if Rob can come in and chime in on that last piece to just kind of clarify. Go ahead. No worries. So in closing, this literally just fixes a loophole that, like I mentioned, tethers folks to a court system that they don't necessarily have to be tethered to. We talked about second chances and making sure that we are helping those folks who either have substance use disorder or some or other type of help that they need outside of the jails. There is no reason to continue to keep these folks and hold these folks based off of technical violations. So that is what the bill does, closes that loophole and make sure that we are not keeping folks in the court system unnecessarily and costing the state more money.
Thank you, Delegate McClure. Delegate Williams, you had your request to speak button on?
Madam Chair, I have to remember to turn that off. I'm sorry.
All right. See, I actually looked at the screen this time. Yeah. A motion is in order. Any comments?
To report?
It's been moved and seconded that we recommend reporting HB 1252. Please open the roll. Members, cast your vote. HB 1252 reports on a vote of 7-0. Thank you, Delegate McClure.
Thank you, Madam Chair, members of the committee.
And now the last one who is not on the committee is Delegate Weber. And he's not here. So now we return, and again, out of courtesy, I'm going to hold mine because I'll be here no matter what. The next one then is Delegate Coulson, HB 457.
Thank you, Chair Watts, and again, esteemed committee members. You have before you House Bill 457, and before we begin, I would like to alert you that there is a substitute.
Report the substitute.
Madam Chair, members of the subcommittee, there is a substitute. There's a myriad of changes through this bill. It has mostly language in new subsection B regarding what types of programs are being offered or how much credits are being obtained, who they're being certified by, how the accrual rate goes through, what the probation officer has to do, what types of information is requested to verify these activities, and then subsections C, D, and E going forward with existing law, just stating what this new code section would not apply to, and how it does not override any other existing statutes.
And if I could speak to the substitute as well. Chairwoman Watts, I would add that the substitute language was done after conversation with VACO, with our probation officers, and with various stakeholders on ways that they thought the language could be improved to better encapsulate what's happening in Virginia.
Thank you. Motion is order on the substitute as reported.
Madam Chair, I move the substitute.
Second. Is there a comment on that motion? All those in favor say aye.
Aye.
Opposed? The motion has the bill has been amended. Delegate Williams.
Yeah, question for council.
Please.
I was curious because I've talked to the patron about this. Is there anywhere in the code section that it talks about credits, how it's defined, where it comes from? Because this particular code kind of just jumps straight into credits. So, like line 19 talks about completing 15 credits. Is there anywhere else that this is talking about or explaining how these credits are calculated or talked about? I'm sure it's in one of these code sections. I just don't want it to be not defined.
I'll do it. Madam Chair, Delegate, I think that's referring to educational credits, like at an educational institute. So like when you go to college and you complete 3 credits per class or something like that.
Follow up.
Please.
So that's not credits as in serving time credits or probation credits.
It sort of does the same thing on line 30, where it just says a defendant shall not begin accruing credit. So I'm just making sure that everybody knows what we're talking about, because that looked random when I first looked at it, and I talked to the patron about it. So if it's good and makes sense, then I don't have any issue with that language.
And Chairwoman Watts, I'm getting a primer on procedure here. So I also believe there is one additional amendment as of today that is a clarification that I believe our staff attorney would also like to add. So I believe it will be a substitute with an amendment, if it is the will of the committee.
If you could report that, please.
Madam Chair, on line 56 at the end of that section or paragraph, and I'm still working on the actual language, but it's going to be something like the decision of the probation officer as to qualifying education, employment, or treatment is final and not subject to appeal.
Is there a motion on the amendment as reported?
Madam Chair, I move the amendment as reported by council.
Okay, any discussion on that amendment? All in favor say aye. Opposed? Okay.
Madam Chair, may I speak to the bill?
Please.
So the goal of this bill is to provide incentives to reduce probation periods by encouraging pro-social behavior. I believe it was alluded to in an earlier comment that if we're having probation, one of the goals is to make sure that we're helping people get on their feet, get well-paying jobs, and reintegrate into society in a successful way. This is what this bill attempts to accomplish. There's a variety of metrics that we look at that we classify as pro-social behavior. I would note that all of them are research-backed and supported by evidence in the over 20 other states that have done probation incentives. And I'm happy to answer questions about those. Those are states, Florida, Texas, Nevada, and across the United States. We all know that there's a ton, we all definitely know because we have listened to it, that there is a ton of work to be done in Virginia to build a criminal justice system that works and that builds on a goal of rehabilitation and reintegration. And this bill, I believe, is a piece of the puzzle. It is researched and data-driven and shown to reduce recidivism, increase community stability, and make Virginia safer. And when I say data-driven, I'm drawing from the case studies in other states, as well as some studies from Virginia about what pro-social behavior leads to better outcomes for those who are released from incarceration. So I believe that probation incentive programs are common sense. I would argue they're also common ground, achieving bipartisan support in various states. They lower costs. They promote pro-social behavior among folks exiting the criminal justice system. I'm pleased to have worked with a wide array of stakeholders on this bill, many of whom are here to testify. I'd like to also just note that Sarah was especially helpful, and we added in a provision about peer recovery specialists and that programming, and I would be happy to entertain questions and testimony on it.
Thank you. Seeing no request to speak, all those in favor of the bill, please come forward to the microphone.
Madam Chair, members of the committee, I'm Benjamin Knotts with Americans for Prosperity. I want to focus on the fact that these people are already out in the public. This creates incentives for them to take that process in stride. This will help probation officers. It'll create incentives for them to get in touch with their probation officers. We strongly support the bill. Thank you.
Thank you.
Sheba Williams, No Left Turns. We support the bill. Thank you.
Thank you.
Taj Manheft with the Humanization Project, also on the steering committee for the New River Valley Reentry Council. We support the bill for the aforementioned reasons and also because we work daily with people whose lives are hindered in their ability to move forward by the probation process already. Creating some incentives is the only way to make this an effective way to move, for us all to move forward in a better way. Thank you.
Thank you.
Thank you, Madam Chair. My name is Michael Sizemore. I serve as the Advocacy Manager for Substance Abuse and Addiction Recovery Alliance in Virginia, also known as SARA of Virginia. And our membership represents thousands impacted by substance use disorder. And we are so grateful and thank you for the delegate for adding this amendment to the bill to include peer recovery specialist training as an approved option. Peer recovery specialists have been proven instrumental in the recovery journey of many individuals throughout the Commonwealth. These people have paid their debts both financially and by serving time as correctional residents. By completing a peer recovery specialist training program as approved by the DBHDS, they can transform past infractions into a beacon of hope for those who are also grappling with addiction and crime. Through mentorship, recovery groups, and more importantly, shared mutual experiences, they can turn these experiences into journeys towards sobriety and advocacy for recovery. This approach has significantly reduced relapse in the community, in the recovery community, and lowered crime rates and criminal activity. Therefore, we fully support it and urge you to advance it to its next stages. Thank you, Madam Chair.
Thank you.
Madam Chair, members of the board, my name is Sincere Allah. I represent the State Organizer for Reform Alliance, and for the aforementioned reasons, I support and we support this bill. Also, I'd like to thank Delegate Carlson for bringing this bill up. I would like to also add that we're looking at probation for all intents and purposes to be an extension of success into reacclimating an individual back into society from incarceration, not an extension of punishment, which it has previously been used for. So again, we support the bill.
Thank you. Anyone here speaking against the bill, please come forward.
Madam Chair, members of the committee, Eileen Longenecker with OES at the Supreme Court, and our committee of judges who review bills has recommended that the court system oppose this bill. I appreciate the time that the delegate gave me to speak about this. Fundamentally, they feel this crosses the line into judicial decision-making. The court heard the case, the judge heard the case, heard the facts, decided the sentence, and set the period of supervised probation, and feels like that is a decision for the judges. From a technical standpoint, should this bill go forward, I think the issue is throughout the bill, it's talking about, like on page 2, the court shall reduce the defendant's supervised probation period by 60 days. The court shall reduce it for this, shall reduce it for that. Ultimately, the court is not making any of those decisions. The court, according to the last paragraph, or second to last, couple of last paragraphs, when the probation officer determines that the amount of time that the person has been on probation equals the credits as calculated by the probation officer, not as calculated by the court, then the probation officer shall advise the court that the credits equal the time already served on probation, and the court shall enter an order discharging the person from probation. And so this is not court decision-making. From a process standpoint, it did concern the judges because it makes it seem like they are the ones making the decision to reduce the probation period by taking into account these different things and the credits, and the court shall reduce. All the court is doing under this bill really is entering an order when advised certain piece of information by the probation officer, not making any decisions on any of that or calculating any credits. And so, Madam Chair, you often raise grammar issues, and perhaps this is an example of one of those. I think if the passive voice was used for these various parts, it would take the court out of it, while still remaining the obligation for the court to enter the order still remaining. So if, for example, on line 17, it said the defendant's supervised probation period shall be reduced if, it's not the court. Again, it's not the court doing that reduction. It's simply entering an order, shall enter an order when advised of information by the probation officer. Same thing on page 2, line 36, line 38, line 41. If all of those were changed to the defendant's supervised probation period shall be reduced by 60 days, it's, again, I don't mean to repeat, but it's the probation officer who is doing those calculations. And so I think our judges would feel better if this bill is going forward, that it not read as if the court is doing the reduction. And then one final point on line 62, which I just think is just a technical correction. This was changed, this substitute was changed only to be addressing supervised probation. And I think on line 62, where it says, upon receipt of this information, which is from the probation officer, the court shall enter an order discharging the person from supervised probation, since that is what at the beginning of the bill. But I think the judges would feel much more comfortable about entering these orders where they are not making any decisions. They're simply required to enter the order if the bill didn't read like they were the ones making the decision. Thank you for your time.
Thank you.
Madam Chair,
Delegate Delaney.
I just had a question for Ms. Longenecker. In your discussion with the judges, did they object to the lack of discretion in mandatory sentences?
For this lack of discretion, it is a double-edged sword, because on the one hand, I don't think they want the discretion because they feel like they will be mired in trying to decide, did the person have 13 credits or was it 15 credits? I think adding discretion pulls them into this detailed analysis that I don't think they want. But again, if it's left as they shall do it, I think if the language simply read that they're not the ones reducing the time by 60 days, it's the probation officer who's keeping track of those various things and, you know, accumulating all the credits and then sending a letter. The judge says, okay, they've gotten enough credits, they should come off supervised probation, and then the judge shall do the order. So I don't know if that answers your question, but thank you.
Thank you. I seen online, we also have speaking for the bill on 450, excuse me while I find my place on the sheet, Mr. Fahy, followed by Ms. Haney. Mr. Fahy.
Thank you, Madam Chair. Thank you, Madam Chair. Ramin Fadahi, Commonwealth's Attorney for the City of Norfolk, here on behalf of myself and on behalf of the Commonwealth's Attorneys for Charlottesville and Albemarle County. Anything that we can do to incentivize people to do better is a wise policy decision. The whole purpose of probation is to encourage self-improvement. Delegate Carlson's bill helps to codify certain things that we would wish that everybody would do. Many thanks to Delegate Carlson, Bula Bula, for carrying the bill. And I would ask that the committee support it on behalf of myself and my colleagues.
Thank you. Yes, Ms. Haney.
Erin Haney on behalf of Reform Alliance. We are incredibly supportive of this bill. We are eager to see improvements in the probation system all over the nation, but especially here in Virginia. We think that this bill has incredible tools in it that probation officers can utilize to incentivize progress, to reward people for doing well. The bill is evidence-based and data-driven. And in states where it has passed, we've seen not only a tremendous increase in successful supervision completions, but also a decrease in violations and some great cost savings as well. So we are eager to see these improvements, and we really urge this to be passed through. Thank you.
Thank you. Seeing no one else online, please come forward.
I'm happy to discuss. I do have, can I address Madam Chair, may I address the
yes, please.
Comments? I'm appreciative of OES bringing their concerns, and I think some of it, I did have a chance, it was today, but I did have a chance to talk with our counsel, and we discussed, and I think there's just a difference in our understanding. I do think, except maybe it's just the language, because the way that the bill is read, and I also think it was presented that way by OES, is this is not discretionary for the judges. This is mandatory reductions in probation if this criteria is met. The reason why it has to go through the court is because probation is ordered by court, and so to get it reduced, there has to be a court order. But the intention is not that a judge would be making any of these determinations and looking at the material. So I've consulted with staff attorneys, and that's the legal opinion that I've gotten, is that the way that it's written right now. I'm amenable to changes if things were, but at this point I feel like I've consulted with all the attorneys I can, and I'm an attorney, and this is what it is. And on that note, I would like to reply to that. And then I did have a quick sidebar conversation. I'm sure you guys can all appreciate that these bills with this many stakeholders are constantly moving. And I would like to tell Madam Chair, I'd like to tell Delegate Williams that his point was well received, and that clarification around the credit, educational credit, I believe is what Steve would like to see.
Thank you. If I may respond, I absolutely feel that this bill does present the kind of alternatives that we all want to encourage. And so I will be supportive of it should the motion be made. But from my own prerogative, now this bill has to be referred to appropriations, so time is of the essence. In between now and full committee, as was referred to, the English major in me sometimes, and the person who diagrams the sentences, let us look at whether or not a substitute that clearly identifies where the conditions are met and who then says, yes, this is what is to happen, is clearly enough so that, again, we have judges who are reading this, who are going to be carrying this out, and we want to make very sure that there's not a question in execution based on the way the language is. So if a substitute is in order, I certainly would exercise the prerogative of making the report in full committee and introducing a substitute at that time that stays in same type of content, but perhaps worded differently as how it's carried. We'll see.
And Madam Chair, can I offer at least 2 amendments to get it as close to the final as we can in this one, which would be clarifying the educational credits. And I do take OAS's point about making sure that that last paragraph also says supervised
if we can go forward with those right now, that would be very good.
And then I'd be happy to work and make sure that
please report them.
Okay. Madam Chair, members of the subcommittee, so yes, these would be clarifying amendments. Thank you to Delegate Williams for pointing this out. On line 19, it would just be saying 15 credit hours. That would then clarify that they are educational credit hours from an institution. And then the following credit language that's on lines 30 and 32, just clarifying that that would be accruing credit for a reduction for an activity under subsection B, clarifying that that is a specific credit reduction based on a qualifying activity. And then on line 62, also adding the word supervised in front of probation. And then, and then there'll be some technical fixes for what DLS standard is for what the code should look like. And then are we adding this one?
Okay.
We already did. Okay. So now we all have to report.
Is there a motion on the 3 line amendments as reported to the substitute?
Move the amendments as reported by council.
Yes. Second. And second. Any discussion? All those in favor of those line amendments say aye. Opposed? Okay. Substitute has been so amended. Okay, now, any further questions of council? We operate by motion.
Move to report.
Second.
As amended.
And it's got to go.
And substitute as amended.
Okay, move to report the substitute as amended and refer to appropriations.
Second.
Okay, we got them all. This is triumvirate. Okay, open the roll. Members, cast your vote on recommending reporting 457 and re-refer to appropriations as substitute with amendment.
Thank you, Madam Chair.
The bill then is recommended reporting, referred with sub to appropriation 7-1. And the next one then on the list is HB 834. Delegate Cousins, would you like to go to the podium? Great. Was Delegate Weber here?
Delegate Simons is here. Simon is here.
Oh, okay. All right, we can do. I would have done it before this long one. If Delegate Cousins, I know there are a number of people interested in this, and I do apologize to those who are interested, but we have at least one person here who is not on the committee. Delegate Simon, if you would like to present your bill, HB 1114.
Okay, I will do my best to present this bill. It's substantially different than what I introduced, but I think in a good way. I think we've been working with outside counsel and DLS counsel here to achieve the desired outcome of the introduced bill in a cleaner and tighter fashion. So I think that you all have just received a committee substitute.
Yeah, Madam Chair, members of the subcommittee, there's a substitute. It should be just passed out to you by outside counsel Mutnick. Excuse me. There was a previous version that was passed out, but this is now the most up-to-date version of the substitute that the Delegate Simon will be presenting. It's posted on LAS now, and I'm going to turn it over to Mr. Mutnick to explain what changes he's made to the bill.
Madam Chair, the substitute changes some of the language on 16.169.24. It says that any failure to appear, a person who fails to appear before any court shall be punished under 19.2.128. The next statute is 18.2.456. The deletion of subsection 6 remains from the original bill. However, the last line says any person charged with a felony offense, misdemeanor offense, or released on a summons shall be prosecuted for failure to appear under 19.2.128. And then we turn to 19.2.128, which now includes both the language determining or telling the court what would be willful and the mitigating language there, the fact that the court should not find anybody guilty if they're incarcerated in a correctional facility or if they were in court in another court and they appeared. And then finally, it deletes the distinction between a felony and a misdemeanor offense, and felony misdemeanor failure to appear creates one crime which is classified as contempt and punishable by a fine of no more than $100 and imprisonment of no more than 2 days, either or both. And then finally, the language that was originally in 18.2.456 is moved here and says if a person does not appear in court as required, the court shall first issue a rule to show cause summons returnable to a future date. If the person fails to appear at that hearing, the court then may issue a capias.
The substitute has been distributed. Are there any questions on this language before us? If not, a motion's in order.
Motion to adopt the substitute.
Second.
All those in favor say aye. Opposed? Okay. All right. The substitute dated 1/31 is before us.
At 4:20 p.m., right? So, which was about 40 minutes ago, right? So this is the latest version. Madam Chair, members of the subcommittee, first I want to tell Delegate Coulson your bill passed in civil sub, and Delegate Cousins, we're happy to take your bill by for the day. We're going to be very accommodating to you. Delegate Hope, your bill passed in civil sub. We're very gentle with it. So just giving everybody an update on where we stand.
Moving right along.
Moving right along. Madam Chair, members agree. So what this bill attempts to do basically is to essentially decriminalize failure to appear and say, look, we've got remedies for this that are contempt remedies, but we don't want to pile on new crimes when somebody fails to appear and it's not a willful action, and we don't want to substitute a new crime. So you can be guilty of a relatively minor crime and then get charged with a felony when your bus doesn't show up to get you to court on time, when your car breaks down, or in some cases when you're in the custody of the state and the reason you couldn't get to court was because somebody didn't get the memo, somebody at the Commonwealth Attorney's Office didn't notify the right people to get you where you needed to be on time. So the bill, as you heard Mr. Mutnick explain it, essentially gets rid of 18.2.456, and we just say you're going to be guilty under the civil statute, the 1900 section, and then specifies in certain circumstances where you'll never be guilty of contempt, and then gives some guidance to judges on what constitutes willful failure to appear. Did I basically get that right, Mr. Mutnick?
Mm-hmm. Delegate Williams.
Yeah, question for Patron. I just have a few concerns because one of the things you probably know is like sometimes if somebody fails to appear, it's because they're in jail, they'll put a hold on them, and then when they're done with that sentence or whatever, they'll get transferred. I'm a little bit worried about the release, rearrest, rebook, rebond kind of type issue just in that circumstance. But I also want you, if you don't mind, talk to me about witnesses, because witnesses sometimes don't show up, and for various reasons. And if I'm concerned that we're losing some teeth, and witnesses might say, well, it's not worth it for me to go, and thus we can't move any prosecution forward. I'm just worried about that delay and that confusion. So if you can help me with that, that'd be great.
So I don't know that witnesses are gotten to in this bill. This bill talks to any person charged with a felony offense, misdemeanor offense, or released on summons who fails to appear. So this doesn't really affect the witnesses who fail to respond to a summons or a subpoena. This is like somebody who's already been charged with a crime. We don't want to just essentially double up that crime if they can't get to court on time.
Is there follow-up? No? Any other questions of the patron of council? Anyone here speaking in favor of House Bill 1114, please come to the front.
Madam Chair, before they start, can I have a question for council before they start?
Before you start, if you could proceed with your question.
All right, council. Failure to appears are always weird, and the contempts are always weird. There's several code sections in here. Are any of them part of the ones that you have to show up because you received a subpoena?
Madam Chair, Delegate Williams, so witnesses would be, if they failed to appear for court, would be prosecuted under 18.2 456A5, which is not affected by this bill. Which is disobedience to any lawful process.
Okay.
All right, thank you. Proceed.
Thank you, Madam Chair, members of the subcommittee, and Dominique Martin with the majority, but also speaking in my capacity as a member of the Pretrial Justice Coalition, a coalition of organizations, 25-plus organizations dedicated to pretrial reform, including defense attorneys, bail organizations, community support organizations, data analysts, scholars, reentry and recovery specialists, and human rights organizations who all agree that this was a top priority for us to try and address this session. And then also just wanted to express the support of
My apologies. I thought that sounded a tad weird. Hopefully I don't have to repeat all of that. But just also want to express support for those who had some other kind of current conflicts with other meetings going on, including the Commonwealth Institute, Rise for Youth, and the NAACP, who also expressed their support. And we hope you can express support. And we thank the delegate and council and everyone that's worked with us to get to this point thus far. Thank you.
Thank you.
Thank you, Madam Chair, members of the committee, and thank you to Delegate Simon for bringing this legislation. Maisie Osteen from the Legal Aid Justice Center, and we fully support this bill. To address Delegate Williams' comment, this doesn't in any way stop courts and if people are incarcerated in other jurisdictions from coming over and handling their business, and hopefully it actually incentivizes taking care of issues prior to release so that when people can release, they can be released free and clear and start back on their path. Thank you very much, and thank you for this bill.
Good afternoon again. Sheba Williams of No Left Turns, also a member of the Pretrial Justice Coalition. We support the bill.
Thank you.
Rob Hogan, Class Justice Forward, we support the bill. I just want to add a few comments. People rarely intend to miss their court date, but our legal system goes to great lengths to punish people even when unforeseen circumstances prevent them from making it to court. Charging people with an additional crime for failure to appear leads to unnecessary expenditures of the legal system's resources, and it can significantly impact the people charged. In 2019, there were approximately 28,000 people who were charged with failing to appear, even when their original charge was only a misdemeanor offense. And of these, 2,200 of them were convicted of the failure to appear, even though the original charge was dismissed. So they end up with no substantive charge, but just the failure to appear on the record. So we support the bill. Thank you.
Thank you.
Madam Chair, committee members, Amy Willard with ACLU of Virginia, and we support the bill. Ask for the committee's support.
Thank you.
Madam Chair, members of the committee, Taj Mainheft with the Humanization Project. In addition to all of the aforementioned reasons, we support the bill because of the way it will help reduce collateral consequences. We work often with people who have these detainers as a result of failures to appear that happened while they were already incarcerated, and then those detainers disallow them from participating in programs while they're incarcerated because of transfers and other such technicalities that can't be cleared up until after they're out then. So this would help undo that. Thank you.
Thank you. Is there anyone speaking against the bill? Please come forward.
Good still afternoon, Madam Chair. Nathan Green, Commonwealth Attorney for the City of Williamsburg and James City County, here speaking on behalf of the Virginia Association of Commonwealth Attorneys. There are really, if you go to court on criminal cases, there's really two types of failures to appear. There are the failures to appear that have been talked about at length today. The ones that are maybe arguably willful, oversleeping, missing a bus, transportation issues, kid issues, those are not the ones that we have the concern about. Those are ones that the court is most uniformly doing in some way that is consistent with, I believe, justice. If you have called in, if your attorney knows where you are and knows of that reason, they issue a show cause. If no one knows where you are, if your attorney has to basically be silent about your whereabouts, now the court's going to get a little bit more concerned, and in those cases, a capias might be issued. But even that's not really the association's concern. What we are the most concerned about is the encouragement that this would have of the more serious type of failure to appear, the very willful, the I'm out on bond, I'm running, I am out of here because if they catch me, the worst that can happen to me is I get 2 days in jail. But if I can stay away long enough that my victim isn't around anymore, that the worker at the store has moved on, if I can hide long enough that they can no longer prove my case, well then I've beaten the charge, and the worst they can do to me is find me guilty of failure to appear and give me 2 days in jail that becomes 1. The willful individuals that are avoiding coming to court to face their serious felony offenses because they know there's no consequence for it, that is our concern.
Thank you.
Madam Chair, members of the committee, Eileen Longenecker with OES at the Supreme Court, and this substitute is very different from the original bill, and the judges had, our committee of judges who review bills had significant concerns and strong opposition to the bill as filed. I would say with the substitute, the primary piece the only piece I think the judges would oppose, and I'd make a comment about another piece, is this issue of a show cause having to be done before a capias. And the reason is this. First of all, it should be in the court's discretion. The court is handling these, the courts are handling these appropriate now. As Mr. Green indicated, if this is the first time someone has not showed up and they have no history of failure to appear, the judge is most likely going to issue a show cause. The problem here is that some defendants have no fixed address, so requiring the judge to have the clerk issue a show cause for no fixed address, so it's not going to get to the defendant. It's not clear from the language if the court can issue a capias if it knows the show cause did not get to the defendant. So I think that's a concern. And secondary, you know, the courts see some people regularly. The courts might know that a defendant has numerous failures to appear on prior cases, is kind of habitually a failure to appear. And this might be the first failure to appear on this specific case. But with the history of failures to appear, a judge might feel it's appropriate to issue a capias because of that history. And this language would require the judge to have a show cause done first. And so that's the main reason. And then I think, not having had a chance to review this substitute with the judges, but I would simply point out, I think they would be concerned that under A5, which is how a witness might be punished for failure to appear, the fine is up to $250 and 10 days in jail. But if a defendant doesn't appear for court, it's up to $100 and only 2 days in jail. So I think it would concern the judges, if I were to run this provision by them, that a defendant would have a lesser punishment for failure to appear than a witness would. So, thank you.
Thank you. Online, I have Ms. Jessica Sapalio. Please proceed.
Thank you, Madam Chair. My name is Jessica Sapalio, and I'm a volunteer with the Williamsburg-James City County Coalition for Community Justice, and we're members of the Virginia Pretrial Justice Coalition. We support HB 1114. Our local court watch program in Williamsburg has observers in court nearly every day of the week. And we constantly see people who are trying to get to court, who have transportation issues or unhoused or have conflicting court appointments in other jurisdictions. And these people are given additional criminal charges for failure to appear. One defendant in our court was charged with a $12 larceny and was then charged with 2 failures to appear because he was unhoused and circulating between relatives' houses. So did not receive notice. He therefore faced an additional 2 criminal charges when the original charge was only for a $12 theft. When a failure to appear like this is listed on someone's record, there's nothing that distinguishes missed appearance due to unforeseen circumstances from actual willful flight. So someone who misses a court appearance for childcare falling through or a flat tire could in the future be considered a flight risk and held without bail. And I just want to mention that, of the nearly 30,000 people that were charged with failure to appear, only about 8% are actually convicted. So, the concern about this being, people are, going to take advantage of this, I really don't think shows in the numbers. So I hope that you will vote to help make our justice system a little more humane by supporting this bill.
Thank you. Seeing no one else to speak, Patron has the last word.
So, Madam Chair, members of the subcommittee, I think that testimony kind of worked out well. I mean, what we're hearing is from the Commonwealth's attorneys and the judges is trust us, right? We need all these very harsh remedies and abilities, but we'll only punish the people that really, really deserve it. And that's what you elected us, and that's what you've hired us to do. And so just trust us. We won't use it. And then we hear the actual stories from the practitioners in the courtroom, about the $12 larceny case that turns into multiple failures to appear for somebody who's unhoused. And so, I believe that the folks who came and testified actually believe what they're saying, that this isn't really a problem, that they can distinguish those cases. I also believe the advocates that have come and said this actually is a real problem, and that it's unjustly causing people to be charged unjustly with crimes, carry convictions that they don't deserve, and then have to deal with the collateral consequences of those convictions. And so on balance, while I understand the concern that we've heard from the opponents, I think that the Commonwealth's better served and justice is better served by passing House Bill 1114. So it would be the will of the subcommittee to recommend passing to the full committee.
Thank you. Seeing no request to speak, a motion is in order.
Move to report. Second. Move to report the substitute.
It's been moved and seconded to report HB 1114 with substitute. Please open the roll. Members, cast your vote. HB 1114 is recommended to report with substitute by a vote of 5-3. Okay.
Thank you, Madam Chair. Thank you, members of the subcommittee.
Thank you. Seeing no other patrons in the room, we are back now to HB 834. Delegate Cousins.
The Zoom for this one, because there's so many people.
Thank you, Madam Chair and members of the subcommittee. I do have a substitute.
Madam Chair, members of the subcommittee, the substitute has been posted on LAS and distributed to you prior to the meeting starting. What this substitute does is it changes the format of the bill from being kind of a blanket 15-year served sentence for any type of sentence bill to a tiered system of 25 years served, 20 years served, and 15 years served based on certain enumerated offenses within the bill. And then it continues throughout with the typical procedures that were in it beforehand. And I'll let the delegate speak to more of any other changes that might be with the bill.
Yep, thank you. So I'd like to ask the committee to accept the substitute.
Substitute?
Madam Chair, I move the substitute.
Second. All those in favor say aye.
Aye.
Okay, and then I have 2 slight amendments. The OES offered a few line amendments. So line 97, after the first Commonwealth, we will insert "or upon the court's own motion for good cause." And then on line 153, after hearing, insert "or as soon after as practicable." And then council also noted an amendment that one of the offenses covered in the sort of 20-year section only has a maximum penalty of 10 years, so we'll have to strike that. So I'll let him speak to that.
Madam Chair, that would be on line 24. It's Romanet 11. A violation of 18.2.371.1 only has a maximum penalty, depending on the highest penalty you can get under that code section is a class 4 felony, which is a max of 10 years. So it doesn't need to be in this section.
Madam Chair, I move the amendments as reported by the patron and council.
Thank you. All those in favor of the line amendments as reported, please say aye.
Aye.
Opposed? Okay, the substitute has been so amended. Delegate Cousins?
Yes, thank you. So as our attorney mentioned, this legislation would allow incarcerated Virginians who have served at least 15, 20, or 25 years of their sentence, depending on the offense, and who have been rehabilitated to petition the judge for sentence modification. Individuals can only petition the courts twice, and if their first petition fails, they must wait 3 years before filing a new one. When considering the petitions, judges are asked to take into account how the person has worked to rehabilitate themselves while incarcerated. This includes the history and characteristics of the petitioner at the time of the hearing, which means the petitioner's disciplinary record while incarcerated and the petitioner's efforts to participate in any educational or therapeutic programs. This legislation takes into account victims of crime as well, and allows them to file both a victim impact statement with the court and to also appear at the hearing if they choose to do that. For far too long in Virginia, we have assigned long sentences that incarcerate people past the point where it is necessary. Research has reportedly shown that long sentences do not make Virginia any safer, but incentivizing rehabilitation does. Knowing that there's an opportunity for future sentence modification provides a real incentive for people who are incarcerated to take steps to rehabilitate their lives and to return to their families and their communities. Once they are home, people who are released from prison through second look laws in other states have proven that they have the potential to make their communities safer. Nationwide, the rate of recidivism for those states who have implemented second look is 1.6%. And that is compared with Virginia's overall recidivism rate of 20.6%. Second look is also smart fiscal policy. We spend over $1 billion each year to incarcerate Virginians. Our prison system is already too expensive, and it is wasteful to incarcerate people who pose very little risk to others. For every year that a sentence is commuted, $50,000 is returned to the Commonwealth. This is money that can be used to fund our education system, to invest in childcare, and to support our communities. Returning people to the workforce through a second look law is projected to grow Virginia's labor sector by $27 million over 5 years. Second look legislation would generate millions of dollars that would be injected directly into Virginia's local economies through the labor market. We are all more than our worst mistake, and Virginians who have rehabilitated themselves deserve a second chance. Thank you for your consideration of this bill.
Thank you. Are there questions of the patron? Council? Okay, on this one, we have a strong interest. So if all those who are here to speak for 834 would come forward so that I have some idea on what I'm going to ask is, we have done this on other bills in the past. I'm going to ask that you talk to each other, and there is a total block of time of 6 minutes. So, and the same thing will be for those who oppose it and online. We are going to have 1 minute per each speaker because we have many, many online as well. So again, you may end up with saying, and also these people support it, but 6 minutes and the first speaker begins. Thank you.
Good evening again, Madam Chair and committee. My name is Sheba Williams with No Left Turns. My 3-month-old baby cousin was killed by the same stray bullet that killed her mother on April 27, 2021. My childhood friend and her 15-year-old son were killed by her husband November 17, 2018. I lost my oldest nephew on June 16, 2018, and my other nephew less than 2 months later on August 9, 2018. My family is now at more than 20 losses in the past few years, with the last funeral being just days ago. My grief is heavy, my anger is real, my faith is stronger. My father did 4 times more time than for the substance use disorder he suffered than the man who fatally shot my nephew 7 times. Forgiveness is for me. I believe wholeheartedly in accountability for those who have caused harm, but we all know the systems that are in place to serve justice are unbalanced, inconsistent, and need reform. Giving individuals who cause harm to my family a second look doesn't leave my voice out of the conversation as a survivor. I don't ever forget my loved ones when I fight for others who deserve an opportunity to contribute to society. I know that there are people who are sentenced to extreme numbers of years and don't align with the crimes that they were convicted of. People are entitled to be angry and to grieve how they choose, but please do not put all victims and survivors in one category. My family benefited from victim services support. As someone on both sides of this, I encourage you all to address the $30 million cut in funding that the governor's budget takes away to provide victim services versus continuing to invest $1.8 billion in extreme sentencing and mass incarceration when it is no longer beneficial to public safety. I believe that public safety is about making sure we're not wasting resources on incarcerating our way out of society's problems. I believe in this bill. Redemption is for everyone. Thank you.
Thank you.
Madam Chair, members of the subcommittee, Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. We support this substitute and we appreciate the work that has been put into this particular legislation. We also understand and hope the subcommittee members appreciate the complex nature of our support on this matter. As you all know, we're a victim-serving agency with 40 plus years of experience working both directly with those impacted by violence and on behalf of community-based organizations that directly serve sexual and domestic violence survivors. The experience of a victim of violent crime, and particularly sexual and domestic violence, is not monolithic. These are incredibly personal and deeply complicated crimes that more than not involve loved ones, family members, and community leaders who perpetrate this violence. In our experience, and reflected in the data, is the common experience of victims never wanting to use the criminal legal system in the first place, as it often poses a threat to their safety and can feel like a moving train they can't stop. Overwhelmingly, in the aftermath of violence, victims tell us that they just want violence to stop and they want safety, which is what our services provide in communities. This bill would also acknowledge the ways in which victims are far too often criminalized and served lengthy sentences for fighting back against their abusers. We appreciate the work everyone has put into this bill, and we're hopeful that we can all work together to have access to services as we lift up criminal justice reform. Thank you.
Thank you.
Madam Chair, Ben Knotts with Americans for Prosperity. How do Virginians get a modification of their sentence today? Pardons. Pardons swing at the whims of a governor with each election, releasing someone with no victim input, no attorney involvement, and only done when relief is no longer available. This bill fixes those problems. This bill makes it far less likely a dangerous person gets pardoned. If this is passed, a future governor who may try to pardon someone very dangerous would now have to overstep the sentencing court's authority who hasn't reviewed a sentence, or completely ignore the sentencing court who repeatedly ruled this person deserved to serve their full sentence because they are dangerous. The governor also never issues pardons when there is relief available in the court. This bill puts the sentencing court in a position to deter political pardons of dangerous, unreformed offenders, and they will validate the length of the sentence. And I will say this, Don Baylor of the National Coalition of Public Safety Officers says, the front line of law enforcement in our prisons strongly support this bill. It will make Virginia prisons safer for officers by encouraging compliance in our prison, and the public safer by ensuring the review process can encourage incarcerated people to reform while incarcerated. Don Baylor, thank you.
Thank you.
Good evening, Sean Winnow speaking on behalf of the ACLU of Virginia for the reasons previously stated. We do support the bill. We must also make sure that we're investing in victim services, places that provide frontline services that create pathways for safety, justice, and healing while we do this. Thank you.
Thank you.
Rob Hogan, Justice Forward, Virginia. We strongly support the bill. I just note the incredible amount of work that has gone into this legislation over the last 3 years and the energy that's poured behind it. I hope the committee takes that into consideration. Thank you.
Thank you.
Greetings and peace. Former President Donald J. Trump
quoted when he signed the First Step Act, Americans have always believed in the power of redemption. I'd like to see, as a taxpayer, a return on the investment of $1.5 billion for the product that DOC has. Men and women coming back into the community, repairing the torn fabric that they left. 3 great examples of people looking at them differently after committing actually violent crimes are Moses, David, and Apostle Paul. Thank you.
Thank you. And we have about 20 seconds left.
Sincere, Madam Chair, members of the committee, Sincere Allah, State Organizer for Reform Alliance, as well as 2022 pardon recipient. And also one of the individuals that inspired this bill in 2021, so I do support this bill strongly.
Madam Chair, honorable delegates, I'm Akiva Friedland from the Legal Aid Justice Center. Just want to say we strongly support the bill.
And the time has expired, but what I will do for both sides, I would like you just to say, if you represent an organization, the name of the organization, not your name. If you are an individual, just say individual, so we understand.
Virginia Interfaith Center for Public Policy. Thank you.
Santia Nance of Henrico.
Virginia Justice Alliance.
Shanoa Young, I support this bill.
The Humanization Project.
Please just give your name.
I'm not in support.
The time has expired for those speaking for the bill. So if you'll wait, you'll get your 6 minutes. All right. Is there anyone else in the audience who did not come forward, wants to stand up? Okay, fine. Now, if all those who are opposed to the bill will please stand up. Same rule, 6 minutes for total testimony against, and if anyone hasn't spoken, I'd like them to identify who they might be speaking for. Please proceed.
My name is Kristen Hubbard. I became a survivor at 18 years old. I do not have a second chance. I do not have parole, and I never will have parole or a second chance. I don't have the ACLU or the Sentencing Project or the Virginia Justice Center or Humanization Project or Justice for Virginia to provide vital support and life-altering services and proper representation for my life sentence. Chairman Watts, Delegate Williams, and Delegate Delaney, I want to thank you for standing with victims last year. And I'm here with my father, Robert Hubbard, in the back, retired captain of the United States Navy, who grew up in Watts, Los Angeles, and did not choose a life of crime. Many don't. Let's look at this bill that Mrs. Cousins has introduced. For my conviction, how will we reduce the sentence for the armed carjacking, for the armed kidnapping, for holding us captive, for taking us over state lines, for the repeated rape, for the repeated sodomy, for making us dig our own graves, for the repeated beatings, for the impregnation of my co-survivor? Which of these charges do you want to reduce? And for which girl? Because we're already at 15 years or 20 years, right? Which one do you want to choose gets the justice? I just want to end this by saying, I know this should not be a political issue. I think we all have our opinions about crime, but there is nothing like being a survivor of violent crime, and it is quite disturbing and shameful for someone who looks like me to author a bill like this, a woman, a mother, to author or support and submit a bill like this. It's shameful.
Hello, how y'all doing? I'm Mark Whitfield. I'm here on behalf of my daughter, Markia Dixon, that was gunned down in the park here in Virginia. And I look at it like this. You go to the grocery store, right? You look for a deal, right? You get a discount. I don't feel like you should get a discount on the sentence. What is the point of the judge? I sat through 3 murder trials, and you take out the bill that first-degree murder. These guys are not getting charged with first degree sometimes. It's dropped down to second-degree murder. So you doing 25, 30 years for that, and now after half of that, you're getting out. I'm still doing the life sentence, just like she just said. The victims doing the life sentence. Nobody's there for the victims. Nobody's advocating putting bills in place for us. It's like, I sat here today and let's see a whole lot of bills come through here. And it's like people are trying to help out the criminals. Let's get the criminals out here. We need more criminals in the street. Let's get our kids out here right now. Let's make bills and put bills in place so they don't end up in them situations. So we don't have to fight and let's get out of jail 15 years after I do 15, I'd be home. One of the guys was 21 that killed my daughter. He get out in 15 years, he gonna be what, 30, 40 years old? That don't make sense to me. I feel like if you got that kind of time, 20 plus, you there for a reason. It shouldn't be a second chance. My daughter don't got a second chance. These victims, these rape victims don't have second chances. They sit under rocks, they're scared. Their life is changed forever. So we need to think as people, we all human. Like, we can't be letting the criminals go. It's happening everywhere. They're letting criminals, and what they doing, they're repeating. 10 years, dude did 20 years, he'd get out and kill somebody. Anybody sitting behind a wall for that amount of time got enough sense to conjure up a way I can do better to get out here. But what are they gonna do when they get out here? Let's be honest. 1%, I heard 1%, like, that's a little, come on, man. It don't make sense to me. I'm definitely against this bill. It shouldn't be passed, especially for the victims. Think about the victims. Y'all guys that's putting this bill up here, please think about the victims. Y'all say it's programs and stuff. I ain't heard of one. It's advocating for the criminals. You get 25 plus, do your time. You do the crime, do the time. No discounts. Thank y'all.
Thank you.
21 years ago, I walked out of a Norfolk courtroom after the sentencing of Joseph Ludlam for the murder of my husband, Tim O'Shaughnessy. I thought I was done with the man since he had received a 40-year sentence for the murder of my husband. There could be no appeals or hearings as he had pled guilty to first-degree murder and agreed to a life sentence with all but 40 years suspended. He had originally been charged with capital murder, case in point, robbery, grand larceny, and 3 counts of use of a firearm, and would have faced a life sentence without the possibility of parole had he gone to trial and been found guilty. For 20 years, I lived my life as best as I could, trying not to think about being a victim. By the way, I've got 4 sons. My youngest was 9 months old at the time his father was murdered. Unfortunately, this all ended on October 9th, 2023. I was totally blindsided when I received a robocall from Navi notifying me that Joseph Ludlam had a parole hearing scheduled for November 8th, 2023. How is this possible? Virginia abolished parole in the 90s. Since it was a holiday, it was a couple of days before I learned that Ludlam was eligible for something called geriatric parole. Once again, I had never been notified that this even existed. Since October 9th, I have had to relive the events of my husband's brutal murder over and over again. I don't have time to go into all the details there, as I fight to keep his killer in prison. There aren't words to describe, I'm sorry, I'm a citizen and I need to get this across to everyone. Thank you. There aren't words to describe the anguish I have had to experience as I fought against his release under geriatric parole or as I prepare to speak for you today. Fortunately, Ludlam did not receive parole, and I learned in the process that after 23 years, he still shows no sign of remorse for the murder he committed. My family has gone through enough. This bill has been introduced that would potentially let my husband's killer out as he is given some second look. You want to give him a second look? How can you put my family through this again and again and again? I recently learned that the statute relating to geriatric parole indicates the inmate may petition for the parole hearing. However, the Department of Corrections automatically schedules every inmate that becomes eligible for geriatric parole an appointment for a parole hearing.
Thank you.
Can you assure me that the same thing isn't going to happen here? Are we going to inundate the courts by having reviews of every sentence that's been handed down if the inmate has been in jail for 15 plus years? Where is the concern for the victims?
Thank you for your testimony.
We did not ask to be.
We must move on.
The inmate chose to commit the violent crime, yet they are the ones afforded every break and opportunity while the victims continue to carry the burden of fighting for peace of mind and safety. I realize now I'll be fighting for the rest of my life for myself and other victims.
Thank you. At this point, obviously, the time has long ago disappeared. If I can just have you represent a group or just say I am an individual.
So, Madam Chair, my name is Michael Gray, and I'm an individual. And
thank you. The next individual, please.
Can I ask you one question?
The next individual, please. I've tried to be fair on these rules.
This is such an important issue, and for us to be given, I mean, there's only 3 or 4 people here, okay, on this side, and for us to be given 6 minutes, okay, over an issue that's
I do want to remind you that there are more than a dozen people on each side waiting online.
I understand. This
Individual right here, I'll take 1 minute. I won't take 5.
I am not happy with the performance. However, I will let you go forward, but this is not fair to the process that you are not accepting the rules that were laid out equally for everyone, and they have been followed. I would ask you and everyone who follows, including online, to please go with the rules.
Madam Chair, I respect you 100%. I've been sitting here for 4 hours today to come here and have a conversation, and to walk up here with 0 time on here and not be able to have 1 minute to talk to this committee about.
I had hoped that everyone would work together with the 6 minutes so it was divided most effectively. Unfortunately, that did not occur. Thank you.
Okay. That's my son. He was shot and killed. That's the last picture I have of him. Okay? This gentleman right here, he's been moved 3 times. He's in a state penitentiary now. Okay? We want to give him a second chance. I spend thousands of dollars. If you haven't seen this billboard, okay, all over Virginia, all right? I have it in 7 states. 7 states. I have over 50 of these billboards up to try to save people's lives, okay? This is important to me, and I'm not going to sit here and argue. These individuals need to speak. But I don't know if you ever lost a child. I lost my first son, okay? When you lose a child, that's the worst experience a parent will ever feel. And the gentleman that stood up here and said we're constantly fighting for these individuals that are in jail to get them out of jail, I hear you. But where are our rights? Yeah, that gentleman gets out of jail, and I heard, yeah, well, you can come back to the next hearing. We can go through this all over again. I'm sorry. I completely oppose this, and I hope each one of you understand. If you've got an individual, if you've got a child, if you've ever lost someone, thank you.
The next speaker, please give your name or your organization.
My name is Melinda Wallen, and I was a mother of Jimmy Wallen, and I'm an individual that opposes this bill.
Thank you. Please, we understand everyone is opposed. Please give your name or your organization. Thank you.
Nathan Green, Virginia Association of Commonwealth Attorneys. We apologize for taking the committee's time.
Thank you.
Respectfully, I'd ask for 1 minute for Ms. Wallen. I drove to Richmond twice today, beginning at 4:30 in the morning, and her son died in her arms, and she just wants 1 minute. You've been here all day. Please.
The next speaker, please.
Brandon Robleski, Attorney General's Office. Thank you for hearing the witnesses.
Thank you. And now online, and I'm going to try to help each one. I want to indicate that I have on the list, speaking first, those speaking for it. At this point, we have a total of 13 people who have registered to speak. If you can wrap up in less than a minute, it would be greatly appreciated, but obviously you can't organize to speak within a block of time as I had hoped the other speakers would. So I'm going to announce the speaker and the next one after. Please make sure that you are not on mute so that your testimony can go forward. As I understand, there will be a 1 minute time that you will see, and they will be cut off. Is that correct on the procedure? I will, okay. As you can hear my voice, the first one is going to be Mr. Fahy, and followed by Aaron Haney. Mr. Fahy? The clock is running. Mr. Fahy? I don't see him. The next speaker then is Aaron Haney, followed by Juanita Belton. Ms. Haney? Do we have technical problems? Ms. Haney? All right, let's try the next one then. And I think that was, in fact, my problem. Thank you, Ms. Clerk. The first one should have been Juanita Belton, and followed by Pauletra James. Juanita Belton, please speak with us.
Good evening, Madam Chair. Juanita Belton, part of Sisters in Prison Reform, who are also co-authors of this bill. I'm also a victim of sexual assault at the age of 15 and also domestic violence from the age of 20 to 25. I wholeheartedly believe in this bill. I believe in second chances. I believe that victims need the resources to heal. I believe that I've spent the last 28 years of my life healing. And because of that, I've been able to help my friend Sincere Allah, who sits there right now in that room, get out of prison. So it's very important that people look at redemption and grace, because that's what's needed. We all victims are not people who want people to spend the rest of their lives in prison. It doesn't help me. It doesn't make anyone safer. So thank you.
Thank you. The next speaker is Pauletra James, followed by Kimberly Jenkins Snodgrass. Pauletra?
Good evening, Madam Chair and committee members. Thank you. My name is Pauletra James. I am a mother, a wife, an advocate, and a two-time victim of sexual assault, in which one was rape, where my son was born. And I am a person that believes that people redeem themselves. Unfortunately, I will never get justice for my sexual assaults. One was a family member, and one was an individual when I was in the military. So speaking on behalf of, victims, I believe that redemption is possible. I also believe that individuals rehabilitate and that individuals can change. I also believe that this state needs to put forth more money towards helping victims and victim services, so that they can get the support for the public safety and the healing that they need. Thank you.
Thank you. The next speaker is Mrs. Snodgrass, followed by Mrs. Wahet.
Good evening, Madam Chair. Good evening, Madam Chair and committee members. I'm with Interfaith Action for Human Rights. I am the Senior Advisor for Criminal Justice Reform, and I support HB 34, and I yield my time to other participants.
Thank you. The next speaker is Mrs. Wahet, followed by Ms. Whitaker.
Thank you, Madam Chair. Thank you, Madam Chair. In the name of Allah, the most gracious, the most merciful, I'm Fatima Muwahid, speaking for my husband, Talib Muwahid. Talib has served 23 years of a 53-year consecutive sentence, with my life expectancy being approximately 13 years. Due to heart failure, I fear that I may die before he is released. He is no longer that impulsive, angry, uneducated, and hopeless 20-year-old who committed his crime. In our faith, we believe in repentance and redemption. This bill is only an opportunity for the reformed, the families, and most importantly, the victims, giving them the ability to see the work the incarcerated has done to redeem themselves, to testify, and if compelled, to forgive, as forgiveness creates space for healing, allowing victims to have a more fulfilling and joyful life, which may be their only source of support. Passing second look.
Thank you. The next speaker is Ms. Whitaker, followed by Ms. Parker. Not seen. The next speaker then is Ms. Parker, followed by Mrs. Branch Kennedy.
Hi, my name is Dawn Parker. I have a loved one that's incarcerated, but I'm also a survivor. My husband was murdered 2 years ago, and while I hurt daily from what happened, I do recognize it doesn't mean that all people who are incarcerated shouldn't get a chance at returning to society if they have earned it. My loved one inside is a changed man. I support him, and I know that individually his accomplishments speak for themselves. So I support Second Look.
Thank you. The next speaker is Mrs. Branch Kennedy, followed by Mr. Boykins. The next speaker then is Mr. Boykins, followed by Allison Chafin. The next speaker then is Allison Chafin, followed by Kenneth Hunter.
Good evening, Madam Chair and Committee. My name is Allison Chafin. I'm an educator and an advocate, and I'm in support of this bill. But most importantly, as a survivor of rape and domestic violence, this bill not only gives a chance to review sentences for who people are today, but it focuses deliberately on considering victims in the process, such as myself. Are any of us fairly represented by the worst thing we possibly did decades ago? Please support this bill. Thank you for your time.
Thank you. The next speaker is Kenneth Hunter, followed by Janet Gwynn.
I'm Kenneth Hunter on behalf of the Virginia Justice Alliance. I'll just reiterate everything that has been said. And second chances or a second look means just that, a second look, 15 years later, outside of the climate at the time of the sentencing. So Virginia Justice Alliance, we support this bill.
Thank you. The next speaker is Janet Gwynn, followed by Brenda Coles. The next speaker then is Brenda Coles, followed by Leonie May. The next speaker then, the last one that I have that is signed up, is Leonie May.
Good evening, honorable member of the committee. I'm here. My name is Leonie May, and I'm parents of Marvin May, inmate at Buckingham Correctional Center. And I'm also a member of RIHD, Resource and Information for the Disadvantaged, and I'm in support of HB 834. I do want to say that everyone deserves a second chance in life, and this bill would do just that, give the inmate a second chance in life against his whatever he's there for. Rehabilitation is a must for human.
Thank you.
Thank you.
Mm-hmm. And that concludes those who have signed up online to speak for the bill. Now we have 9 speakers who have signed up online to speak against the bill. The first one in the sign up is Paige O'Shaughnessy, followed by Kristen Hubbard. The next speaker then is Kristen Hubbard, followed by, the name is Gravara Strisha. Kristen Hubbard. The next speaker then would be Gravara Sharista. My apologies. The next speaker then would be Francis Ross. Francis Ross, thank you.
Good morning, Madam Chair and all the members of the committee. And I want to first apologize to Delegate Cousin for opposing this bill. And I've been praying on it really hard since it was drafted. And I think that it really is not enough. I really think that they should be able to have their first review after 10 years. And my heart breaks, and I've prayed on this hard, but my heart really breaks for the victims. And I've been a victim, but I also know that we as the victims need to forgive people. And I just want to say that forgiveness is part of you being able to go forward. And I really think that I would appreciate it if they would make a friendly amendment to it and make the first bottom tier be at 10 years. And I appreciate your support and listening to me. Thank you.
Thank you. The next speaker is Lauren Madaw, followed by Dennis Brown.
Thank you, Madam Chair. My name is Lauren Madaw. I am a mother of a 9-year-old sexual abuse survivor. Her father was found guilty on a number of charges in March of 2022, including forcible sodomy, which under Virginia Code holds a mandatory minimum sentence of life in prison. My daughter has undergone therapy since November of 2022 and is still in therapy for PTSD through CHKD's child abuse program. We have done so much work to move forward and lead the most normal life that we absolutely can after experiencing something so harrowing and disturbing. And I just want to say that I do not support this bill as it jeopardizes the safety of so many victims affected by violent offenders and their heinous and unforgivable crimes. So when you think about passing this bill, I respectfully ask you to consider my child, myself, and the many other victims that stand before you today.
Thank you. The next speaker then is Dennis Brown, followed by Tracy Martin. Mr. Brown.
Good afternoon. Good afternoon, Madam Chair, committee members. My name is Dennis Brown, and I am the father of a son who was murdered. My son graduated from high school with a 4.0 in 2 years of college. I'm asking you today, please do not pass a law that will give a convicted murderer one less day than what a judge has given him or her. The person who murdered my son was a 17-year-old boy whose 18th birthday was 30 days away. My son was 42 days away from his 19th birthday. I respectfully oppose the idea of passing legislation that will reduce the sentence of a convicted murderer. A 17-year-old boy deliberately shot my son in the face with a .40 caliber Smith & Wesson that was stolen. Within minutes, law enforcement were able to track him because his cell number was in my son's phone. When authorities went to the juvenile's residence, they could smell marijuana even before entering. His mother was home. Upon searching the juvenile's room, they found bags of marijuana and a sawed-off shotgun.
Thank you. The next speaker is Tracy Martin, followed by Scott Duffy.
Madam Speaker, thank you. I'm Tracy Quackenbush Martin. I'm the Commonwealth's Attorney for Halifax County, and I'm speaking on behalf of the citizens of Halifax County. This is one example. This is Christian Sidner. He was 5 years old when he was lashed to death by the boyfriend of his mother. He died from blunt force trauma and massive hemorrhaging all over his body more than 50 times. This was his cause of death. The person who did this to him received an active sentence of 50 years, and he deserved every day of it on a second-degree murder. If I had to make a decision, and I'm sorry I have not been able to access online the amendments, it's a shame that us online cannot see those yet. But I can tell you that if I had to choose between a first degree and a second degree, and I went forward with the second degree, I probably would have taken my chances if it had made a difference about keeping the victims of that case, the survivors, from having to be re-victimized in 15 or 25 years. No one is recognizing the fact that the court process itself is very difficult for victims. They didn't ask to be victimized.
The next speaker is Scott Duffy, followed by Sharhunda Hubert. Ms. Hubert?
Yes, thank you, Madam Chair.
Mm-hmm.
My name is Sharonda Hubert, and I'm from Lynchburg, Virginia, and I oppose House Bill 834. This is my 2-year-old son, Simeon. Almost 11 years ago, he died at the abusive hands of his father. He would be 13 years old if he were alive today. It's been an indescribable 11-year battle for me to have some sort of normalcy in my life. As stated before, this is a life sentence. My entire family has been deeply affected by Simeon's death, especially my other children. I've cried for the past 2 days. My anxiety's been through the roof. I can't eat. I can barely literally sleep at the thought of this vote. Voting in favor of this bill will be a slap in the face of victims' families like mine. I can't imagine having to relive this and go back to court and heal and go back through it again. I don't believe criminals deserve a second chance before they complete their sentences. Simeon doesn't get a second chance to grow up, and I don't get a second chance to be his mom. So with that being said, I ask you all to please remember Simeon and families like mine when you're voting for this bill. Thank you.
Thank you. And I want to thank all of the speakers. I know it was difficult for many of you to come forward, and we deeply appreciate the fact that you shared with us on this bill. I now have
Madam Chair.
I will recognize Delegate Batten, followed by Delegate Williams.
Thank you, Madam Chair. I just wanted to thank you for allowing each of the people who signed up online to speak for a minute. And I would ask that you extend the same courtesy to the people who traveled here to this room to speak to us in person today. So everyone who did not have a chance to speak for 1 minute, like the folks online did, please allow them to speak as well.
I appreciate the comment that was made. Unfortunately, I know that there were other speakers who 1 minute just wouldn't capture it, and I understand what you are deeply concerned about, and thank you for that comment.
Madam Chair, I'd just like to point out that it disenfranchises the people who actually spent time to drive to Richmond today to wait for hours to be in this room, and were not allowed to speak, where the people who were online were allowed to speak.
Thank you. The next speaker, I believe, Delegate Williams.
Yes, Madam Chair. I've been through this hearing before, and it's very tough, and I was wondering if anybody felt the need to go at ease.
I'm sorry, would you repeat? I'm sorry, Mr. Williams, Delegate Williams. My apologies. The request was, could we go at ease? Yes, let us go at ease for until 6:10. If members could please return to the room and take your seats. At this point, we don't have a quorum. Just a moment. Come back to order. Delegate Batten, you're on the request to speak.
That's on from before.
Thank you. The patron, would you like to speak to the final word?
Yes, thank you. First, obviously I want to say that I am, is it mic on? Okay. First, I want to say that I am extremely empathetic to what victims of crime have gone through, to the experiences and stories that we heard this evening. And I do want to just point out that the legislation does include a process to ensure that victims have a role. Victims are notified when someone has applied for this resentencing. There has to be written notification, and a third party, the judge, will determine if the court has made reasonable efforts to notify victims of the process. The bill also includes an option for a judge to dismiss the petition in chambers
If the judge determines that the petition lacks merit, no hearing will be conducted and no notification will be sent to the victim. Victims are also given a voice in the proceedings, and they have the ability to submit a victim impact statement to the judge. I do want to reiterate and let us be clear that this is not a get out of jail free card for violent offenders. This is a chance for people who have served at least 15, 20, or 25 years of their sentence, who have been rehabilitated and have established the factors. There's a list of factors, a whole page and a half of factors in the legislation that a judge must consider to determine whether someone has been rehabilitated. And this only allows that person to petition a judge for resentencing. Again, it's not a get out of jail free card. We trust judges to hand out initial sentences, and we should trust them to review those sentences. Thank you.
Thank you, Delegate Cousins. I see no request to speak. A motion is in order.
Move to table.
The motion has been made and seconded to lay on the table. That is not debatable. Madam Clerk, please open the roll. Members, cast your vote.
Cousins vote no?
Yes,
Cousin, yes. The motion to table fails by a vote of 3 to 5. Hearing no substitute motion. Is there a substitute motion?
Yes, I'd make a substitute
I didn't see
motion.
the request to speak.
I move to report the substitute. There's no additional amendments, right?
Second.
It has been moved and seconded to we recommend reporting the substitute as amended, and this is one of those bills that is on the list. It also has to be reported to referred to appropriations. And this is debatable. All right. If you are ready for the vote, please open the roll.
Madam Chair, speaking to the motion.
Thank you. Delegate Williams, you may speak to the measure. Please, Delegate Williams.
So this has always been a very hard issue because I've sat through it before, and emotions run high and it's very difficult, and all sides make great points. And I stand as somebody with personal values that I don't think we should throw people away. And forgiveness is important, but I always think that we have to weigh the victims as well. And I think one of the things that I've been working on is working with all parties to see if there's any way that we can get peace in the valley. And right now we're not there, and I'm willing to keep working on this. There's a Senate companion that removes violent felons, and that's something that I'd be willing to look at. But right now, I'm not there. Therefore, I'll be abstaining from this vote.
Thank you. Are there any, Delegate Delaney?
Madam Chair, I will then also speak to the bill, and I appreciate those remarks because I do think that people deserve second chances, and I believe that the experiences that we heard today and testimony of survivors are incredibly valuable. And I think that there is a path to serve all and to make sure that, those who shouldn't qualify will not, and that those who committed the egregious crimes that we heard examples of today will not have access to a provision that would re-traumatize those survivors, but that those who have served time and had the opportunity to find that redemption, that we give that opportunity to give that second look and to give that opportunity for those people, and that is important too. And I think we're on a path there. I appreciate the language that the patron brought forward, trying to get more to that peace in the valley. I think if we move this bill along, we will have the opportunity to continue those conversations, and I hope continue to craft policy that does take into account the very sensitive arguments that all sides on this have made. And I hope
we can find a path before the end of this session to find that resolution.
Thank you, Delegate Delaney. Delegate Hernandez.
I just wanted to take a moment to thank everyone who shared testimony bravely. I know we didn't have as much time as we might have liked, but I do want to thank the people who came here today. In my mind, this bill doesn't guarantee anything for folks. Petitions can be denied where it's inappropriate, where the circumstances warrant that. In some cases, we may want to take a look to review sentences in other cases. I think the witness testimony has been very helpful today, and so I am interested in hearing more as this moves through the process to figure out ways that we can strengthen the legislation. There was mention of a Senate version as well. We take a hard look at that and try to get to the best possible place that achieves the intent while also honoring all of the testimony. It's a difficult thing to do, but that is also why we're here. So, I'm interested in furthering that conversation.
Thank you. Delegate Cardoza.
Thank you, Madam Chair. Delegate, I understand what you're trying to do here. Actually, in considering voting for your bill until I heard those victims come up and speak, and I've seen a lot of things. I've heard a lot of things. Very few things have been as difficult as this is in my life, because I believe in second chances very heavily. But I also believe that some things, even in the Bible, there is an unforgivable sin. And I can't, this is not the way. Maybe there's another way in the future, maybe the Senate bill, I don't know. But I know that I can't vote for this bill. I can't. So thank you for bringing it. Thank you for everyone who came to speak. As I know it was hard, it's hard listening to it. I can imagine you living through it. I can't. I'm sorry for everyone who didn't get to speak and tell their whole story. But I can't vote for it.
Thank you, Delegate Cardoza. If there's no other request to speak, I would also like to say Delegate Batten.
Thank you, Madam Chair. I appreciate the conversation that we're having about the victims and their ability to provide statements during this process, but there are some victims who can never give a statement, and those are the ones who are no longer with us.
Thank you. Again, taking my own moment, we each bring our life history as members of this General Assembly in the laws of the Commonwealth. And certainly the years I spent in therapy dealing with what happened within my family, I cried again and again for the victim and never for myself as I tried to look at what I needed to do to deal with what had happened within our family. However, with all of the years, so I do absolutely sympathize and am deeply grateful for each and every speaker who spoke to the reality of what we as legislators are about to act on. But as a legislator, as I look at this bill, and I look at all of the procedural protections that are there so that a second look is only taken when all of those procedures are satisfied. I am much more comfortable with an individual having the possibility of a second look under all of those protections, with a full hearing of the circumstances, which does not occur in our parole system. It is very perfunctory compared to what this bill is attempting to craft. I have to also vote for moving this bill forward so that that very narrow possibility of a re-look at the circumstances of what happened can be fully heard. Thank you. There are no more comments. Ready for the vote? Please open the roll to report and refer with substitute that's been amended to appropriations. And Delegate Cousins is recorded as voting aye. The vote to report and refer passes by a vote of 5-2. Thank you, everyone, for your participation in this hearing of this bill. On the agenda, we have two more bills on the agenda. HB 1268, Delegate Delaney.
I think Delegate Weber, who's not on the committee,
It is here. Delegate Weber, please come forward on your bill. You could suspend for a moment while the individuals are able to. Delegate Weber, if you will proceed with HB 1427.
Thank you, Madam Chair. Madam Chair, first I have a substitute.
Madam Chair, members of the subcommittee, there's a substitute. It should be posted on LAS at the moment and has been distributed to you all. What the substitute does is changes the new language in the code section to read, however, the court may fix the period of suspension for a period not
is
to
the microphone on?
Mine is, yeah.
His is? All right,
I turned it on. Yes, Madam Chair.
The court may fix the period of suspension for a period not to exceed 3 years for a violation of 18.2-67.4 or 18.2-67.4:2.
Thank you. May I hear a motion? Or any questions on the amendment as reported? Motion?
Move to adopt the amendment.
It has, all those in favor of the amendment as reported, please say aye. Aye. Opposed? Please proceed.
Thank you, Madam Chair. Madam Chair, the bill, as described by the attorney, would extend the maximum length of probation for 2 misdemeanor offenses, sexual battery, sexual abuse of a child between the ages of 13 and 15. Both of these offenses are Class 1 misdemeanors with a period of 12 months for which the sentence could be suspended. The length of probation for these offenses under this bill would become a maximum of 3 years. This is the change in the substitute where the original bill actually left the length of the probation entirely up to the discretion of the judge and for as long as it can go. Whereas this would help cases where no court-ordered programming occurs as part of sentencing, or if court-ordered programming would not last as long as a judge believes is necessary to extend the probation. It allows for length of probation to be extended so that it aligns with the length of court-ordered programs, but it would allow probation to go past the end of such programs for these selected offenses. That's what the bill does, Madam Chair, and we have some folks here to speak in favor of the piece of legislation.
Thank you. I have a question as I'm trying to understand exactly what is before us. It seems like the key words is without regard to the statutory maximum period for violation. Am I not on the right bill? Thank you.
It's a substitute bill.
Okay.
They took that language out.
Not to exceed 3 years. Okay. And again, to understand, you feel that the court does not currently have discretion to fix the period of suspension? Or are you limiting it, or are you giving the discretion? My apologies for not following accurately. Counsel can perhaps guide me.
Madam Chair, so under current law, after the probation reform laws were passed in 2020, the maximum period of a suspended sentence, and so when we're talking about suspended sentence, we're not talking necessarily about supervised probation, but we're talking about the unsupervised period of probation, or otherwise known as a good behavior period. And that maximum period right now is the maximum for which a person can be sentenced to the crime. Class 1 misdemeanor is 12 months, so you can only suspend that sentence for a period of 12 months. There is an exception in current law that if the court orders somebody to do a program or some sort of probationary program, that can be extended until that program is completed. This bill would allow on these two specific misdemeanors the court the ability to allow or to do a 3-year unsupervised or good behavior period.
A couple of follow-up questions. Are individuals who might be in this circumstance, will they be on the sex register?
They could be. If you commit I know for a fact if you commit an offense of misdemeanor sexual battery, but the victim is a minor, you are required to register. I am not 100% sure about the other one, but Mr. Hatcher is looking it up right now.
And while that's being looked up, are the two offenses that we are talking about adult against children, or is it the 3-year difference in age that is also encompassed in those two code sections?
Sexual battery. Madam Chair, sexual battery, the first one does not have any regard to age at all because it is a battery, a sexual abuse that occurs against the will of the complaining witness. So the defendant can be an adult or a juvenile, and there's no age difference requirement. The sexual abuse of a 13 to 15-year-old requires it to be somebody over the age of 18 that commits the offense.
Thank you. Is there anyone, are there other questions? Is there anyone wishing, please go ahead, Counsel.
I was going to say, Madam Chair, that it's on the regular. Yeah. The violation of 18.2-67.4:2 is on the list of Tier 1 offenses for registry. It should be as a third or subsequent conviction.
All right. Is there anyone in the audience wishing to speak for 1427? Please come to the front. Thank you.
Thank you, Madam Chair. Nathan Green, Commonwealth Attorney for the City of Williamsburg and James City County, here speaking on behalf of the Virginia Association of Commonwealth Attorneys. We are in support of the bill. I'm happy to answer any questions, but primarily, not all misdemeanors are treated equally or should be treated equally. There's an enormous difference between a trespass or a petty larceny and a sexual battery or the sexual battery of a child. And this is the child between 13 and 15. And for that reason, we are asking for more good behavior period on just these two limited offenses. I'm happy to answer any questions, but we have a much better advocate than me that's ready to speak.
Thank you.
Madam Chair Watts, distinguished members of the House Courts of Justice Criminal Subcommittee, good afternoon or evening. My name is Rowan Danielson. I'm a 13-year-old and an 8th grader living in Farmville, Virginia, in Prince Edward County. I'm here with you today to speak in support of House Bill 1427. Please accept my thanks in advance for your time in hearing about a very concerning personal experience I endured, one which I think speaks to the need for this legislation. In late December of 2022, I was riding my bicycle home from downtown Farmville after doing some Christmas shopping, and after getting to the summit of a long hill, I stopped on the side of the road to catch my breath. A van that wasn't in good condition passed me, stopped, then reversed, then pulled close beside me. The man inside offered to put my bike in the back of his van and to take me home. I declined politely, and thankfully, for whatever reason, he moved on. I rode home and contacted my parents. My dad drove us back to where the incident occurred, and we went looking for the van. By a stroke of luck, we located it, photographed the license plate number, and reported it to Farmville PD. I still remember the feeling of my heart sinking into my stomach when my dad relayed the news that night of the man who urged me to go with him that day was a registered sex offender. Later, we learned that this man couldn't be violated or charged for this incident because his probation was limited to just 1 year, even though very recently he had been charged with 4 prior felony sexual offenses against children, all of which were pled to misdemeanors. We also learned that he had been incarcerated several years earlier for at least 1 other felony sexual offense. The responding officer, police chief, and Commonwealth's attorney in Farmville all expressed real concern over the seriousness of this incident, given the man's lengthy sex offense history. For this offender, clearly, being off all rules after 12 months was not enough, and I think there are many other sexual offenders in Virginia who need at least some accountability beyond 12 months, given the seriousness of their past offending. Therefore, I respectfully urge you to support HB 1427 and to please accept my thanks for your time and listening about my experience. If you had any questions for me, I am happy to answer them, and if not, I wish you all a great rest of your session.
Thank you for that. Is there anyone in the room speaking against the bill? I believe there's no one online. Is that correct? Having no one online, Delegate Weber, you have the final word on the bill?
Madam Chair, I believe that the testimony sort of speaks for itself.
Okay. I see no request to speak. A motion is in order. It's been moved and seconded that we report with substitute. Clerk, open the roll. Members, cast your vote. HB 1427 reports with substitute by a vote of 8-0. Thank you for your patience.
Thank you, Madam Chair.
And I guess Delegate Delaney, 1268.
I'll go to the podium because I know there's some other people here to speak, and I'll stand near them at least.
Thank you, Madam Chair, and thank you, committee. I have HB 1268. So the bill before you would allow probation and patrol officers to refer probationers directly to a community corrections alternative program prior to a court proceeding as an early intervention. The legislation would allow this early intervention as a timelier utilization of the CCAP as a resource to reducing risk and providing education, career development, and treatment services. In addition, this legislation will enhance public safety by utilizing this resource prior to the probationers committing multiple technical violations and/or new offenses. Due to the opioid epidemic and ongoing need for substance use disorder services for probationers, along with the limited number of service providers throughout Virginia, CCAPs can better serve as a substance abuse treatment referral. Recognizing existent treatment service gaps in geographical areas, this change would enhance probationers' access to residential treatment services. This allows probation and parole officers to utilize CCAPs more efficiently and effectively address supervisees' risk and treatment needs prior to the accumulation of technical violations or supervision and/or new crime offense, which also enhances public safety. While this bill serves as an additional direct referral source, it does not remove or diminish the court's authority and still requires the approval and court order to complete CCAP by the judge or original jurisdiction as a condition of supervised probation.
Thank you, Thank you, Delegate Delaney. Delegate Williams?
Question for the patron.
Please.
COVID backed CCAP up really badly, and I'm wondering if this going to cause problems? Is CCAP up to speed now? Is this going to it sounds like they can go kind of straight to CCAP, and I'm just wondering, can you help me with that idea?
Yes, Madam Chair, and I know we have some folks that are here that can probably speak even more eloquently as to the direct path, but it would give a more direct path directly from the probation officer rather than having to go through a lengthy court process or to first experience a technical violation before one would qualify. But I'll certainly let those with the organization.
Yeah.
Good evening, Chairman, members. To the question posed, Delegate Williams, because of the utilization we've had over the last several years, utilization has been down. So in terms of capacity, there's plenty of capacity with CCAPs. And I know part of what we're doing in the governor's budget was to close the Stafford CCAP because of budget issues. We still have the capacity to manage referrals if this bill is passed. We do strongly support this bill. Thank you.
Good evening, Madam Chair, members of the committee. Sean Winetta speaking on behalf of the ACLU of Virginia, and we do support this bill. Thank you.
Thank you. Is there anyone here to speak against HB 1268? Please come to the front. Seeing no one, Delegate Williams.
Yeah, if you don't mind, can you just lay out like the timeline of how this would come to be? This is after a conviction.
You'd be more.
It seems like it's after a conviction.
And I apologize, I didn't introduce myself previously. Marcus Elam, Corrections Operations Administrator for the Department of Corrections. So what this would, in essence, do would allow a probation officer, if a probation officer is going to proceed with a probation violation, it would allow the probation officer to make the referral prior to going back to court. So it really would reduce the amount of time someone's sitting in jail waiting for a referral to be completed. Currently, you would have to get it back before the judge, find the person in violation, and then prior to sentencing, do a referral that takes 45 additional days. This would get that referral done prior to still having to do the proceedings, but at least when it got to court to be sentenced, you don't have to wait another 45 days for a referral.
Yeah, Madam Chair.
Thank you. If you follow up.
This is a fix to something that we've been working around already, because what we were doing is the judge would get the probation officers to go ahead and see if they qualified and see if we could get somebody in, and then at sentencing, that's when we could refer them. So I understand what this is doing now.
Thank you. Seeing no one else who wishes to speak to the bill, a motion is in order.
Move to report.
It's been moved and seconded to report HB 1268. Open the roll. Please cast your votes.
I always feel like Family Feud, like, good answer. Good bill, good bill.
I could have tried to.
All right, Delegate Watts, HB 77.
Thank you very much, Chairman Delaney. I have one line amendment to, and if that can please be reported.
Yes,
Counsel?
Madam Chair, members of the subcommittee. On the introduced version of the bill on line 109, after the new language B, we're inserting one or. As of right now, it just references subdivision B2, so this line amendment would make it subdivision B1 or 2.
Do I hear a motion to adopt the amendment?
Motion to adopt.
It's been moved and seconded. All those in favor say aye. Aye. Any opposed? All right, the amendment's before us. Delegate Watts.
Thank you very much, Madam Chairman and members of the committee. Let me first start by just laying out the context. This bill was a bill that, the underlying bill was a bill that I carried in 2021. And it was very surprising to me when I did my dutiful homework and found that there were more people in prison in Virginia on charges of robbery than there were of all drug crimes combined. The other thing that struck up at me was that unlike every other offense in the criminal code that we work with, all of them have various descriptions of types of actions under that general category that are different crimes, except for robbery, up until the 2021 when it was changed. Now the code has 4 different degrees of robbery. And what you have before you, while some was done at the time to make sure that the degrees of robbery were reflected in various aspects of the code of how we treat various things that I will go through, there was a cleanup afterwards, that there were code sections that were missed, and that is what is before you. And now just to bring to mind, rather than, as it used to be, robbery up to 40 years with no distinctions, now the code has, 1 refers to any person who commits a robbery and causes serious bodily injury to or the death of the person is guilty of a Class 2 felony, and that's the 1. So when I put in 1, it means that this is what I am talking about. Class 2 would be any person who commits a robbery using or displaying a firearm. So anytime a gun is involved, that's going to fall under 2, and it would be a Class 3 felony. Again, a serious felony, so that's why you see repeatedly through the bill, as I walk you quickly through, is going to be 1 and 2. But also then in number 3 is any person who commits a robbery by using physical force not resulting in serious bodily injury, or by using or displaying a deadly weapon other than a firearm in a threatening manner. And that person would be guilty of a Class 5 felony. And I asked this morning, and there's no definition anywhere in the code of what a deadly weapon is. Isn't that interesting that it's never been defined? So this then becomes the trier of fact is going to determine the deadly weapon. And then finally, number 4 is simply a person or is a person who commits a robbery by using threat or intimidation or any other means, but not involving a deadly weapon, and this would be the lowest category. Someone who just by their presence has intimidated the person to commit the robbery. So with that, walking you very quickly through the cleanup here, and I would say that the amendment that was there was because I was trying to be really, really careful, and I realized we had left out number 1, when a place where it should have been comparable to the other offenses that are in. First, the category that starts on line 15 involves the exception to juvenile records. And so there you are saying that when it comes to all 3, when it comes to that case, robbery is not generally out. It's only if it's a Class 2 or 3 felony, and I indicated that in that wording, that's going to be the first 2 categories that I talked about, so it will be covered even though we take out the word robbery. They are felonies that will be covered as far as sharing those juvenile records. The next one is going to be under 16.1, which is where I added the B1 as well as B2, and that one is a situation where you're talking about someone adjudicated delinquent or of murder, attempted murder, armed robbery, and this is where we're now defining armed robbery as being 1 or 2. And I did insert 1, even though obviously you could have that kind of injury to an individual without a weapon, but it obviously is of the same category as murder or attempted murder, and that's why it is in there. The next one has to do with, on line 162, 17.1, deals with sentencing guidelines, and the change in the language there starts at the bottom of the page. And again, it's separately treating the first two categories from the other two categories. On 18.2, which is down on line 239, this deals with crimes by gangs. And it too makes the proper distinction under predicate criminal act so that an act of violence is properly defined by subsection B 3 or 4 would be comparable to the other offenses that are there as a predicate act under our laws dealing with gangs. Under 258, it has to do with kidnapping, enticing someone with the intent to commit certain felonies. And on that one, it's 1 or 2, because again, it's comparable in the act committed in the circumstances. Under burglary, which is 18.290 on line 265, again, inserting 1 or 2. Under criminal procedures on line 276, under 19.2, we are dealing with sentencing a person twice previously convicted. And again, when you look down on starting on line 284, you're going to see first and second degree murder, mob-related felonies, malicious felonious assault, or malicious bodily wounding. And again, the comparability would be to be 1 or 2. And then finally, well, not quite finally, but it is on conditional release of the terminally ill. Again, someone who has committed 1 or 2 would not be eligible for conditional release for the terminally ill. The assignment to home electronic incarceration on 355. Again, these are talking about someone who is not eligible. That's down on line 365. And since this is dealing with first and second degree murder, et cetera, it is again appropriate to insert 1 and 2 there, 1 or 2 there, and then still under eligibility for parole. Again, quite frankly, the insertion on line 478, as I read it, actually strengthens it that when we add or that causes serious bodily injury to or the death of another, that picks up on line on the first offense. On 51.1, 53.1 on 521, again, this has to do with life sentence, and down at the bottom of the page, we are inserting the language did not in this case, cause serious bodily injury or death of another, or use a firearm. So basically, we are only excluding someone who commits robbery with intimidation. And I think I've pretty much covered it all. On 569, again, robbery is B1 or 2 as comparable to the other acts that were there. So again, I was trying to be absolutely sure what all this was. I had asked VECA if they had anything that wasn't on here or they did not feel that was not on here. I did not get any other additional things that I need to be looked at. So I hope with the passage of time and allowing for that input that, in fact, HB 77 is ready to go forward.
Thank you, Delegate. Are there any questions from the committee? Seeing none, is there anyone here in the audience that is here to speak in favor of the bill? Delegate, you have some folks ready to speak.
Rob Pogenklass, Justice Forward. We support the bill. Thank you.
Sheba Williams, no left turns. A few years ago when Delegate Watts brought this bill forward, we were on a call together and she said, I brought this bill to change the system. And as we talk about second chances and looking back, we see now that our legislators get to look back and make changes for things that were not necessarily correct in our code. My dad did 19 and a half years in DOC for a robbery where no one was hurt and no weapon was involved. Had he had this, he would have done less than 5 years. So we support the bill, and I appreciate you all.
Thank you. Is there anyone here to speak in opposition?
Good evening, Chairwoman. My name is Bethany Harrison. I'm the Commonwealth's attorney for the City of Lynchburg, here on behalf of Virginia Association of Commonwealth Attorneys. One of our members did come speak to the patron about the bill, and I sent an email this morning with my specific objections. Certainly glad to see the amendment. That was one of the issues. But it can be summed up in this way, is the lack of including robbery B3 in any of these places throughout. Certainly we can understand the exclusion of B4 by threat or intimidation, but the issue is by excluding under 18.2-58 B3, robbery by force or use or display of a weapon. It can include use of a real firearm, and you may wonder, well, how is that? Because we have B2. That is because under B2 we must prove that it is an instrument designed to expel a projectile by explosive material. We must specifically prove that. And we can't prove it in cases where the firearm is not recovered, or if the firearm is held at a distance from the victim, maybe the victim's not familiar with firearms, you can't distinguish between an airsoft gun and a real firearm. Also, someone can use a knife on the victim. They could even cut the victim with the knife. But if it does not result in serious injury or death, then it does not qualify for B1 or B2. Someone could be beaten black and blue, but if it does not result in serious injury or death, it does not qualify for the higher offenses and would be under B3. So in the specifics here in line 19, the inconsistency of removing robbery as an offense where the public may obtain certain juvenile records, given that burglary is still in that list where the public may obtain a record, but robbery is just omitted altogether. No levels, just omitted altogether. Also in lines 108 and 109, classifying serious juvenile offender, but for armed robbery, where we did include B1 along with B2 here, but with B3, again, we have that issue where you can use a weapon, even a deadly weapon, and it would be excluded from including that and considering a juvenile a serious offender. In line 272, removing B3 from the enhanced, and well, in B4, from the enhancements for a burglary under 18.2-90, when we have historically and currently recognized the home, the dwelling house, as a special protected place where everyone should feel safe. So any person is in their home and someone comes in wielding a knife, I think they would agree this is a violent offense and should be held to a higher standard than the lesser burglaries. And lastly, line 288 removes B3 from the series of offenses for recidivist statute where it no longer considers B3 a violent offense. Someone can pull a knife, stab you with a knife, and we would no longer consider it a violent offense under this current iteration of this bill. So for those reasons, we oppose HB 77. Thank you.
All right, any questions from the committee? Delegate Watts.
Yes, and again, if that guy had communicated that to me and I didn't get it, I do apologize, but I honestly did not see that. Sorry. But on the points raised, I would point out to the committee that the bill before you deals with convictions under these 4 categories. And obviously in conviction on those 4 categories, the prosecution has made the case, whatever it may be, and it was determined that 3 was all that could be proven. So I would point out that the what if was not held up in court, was not the conviction in court. And I would further conclude by saying one of the reasons why I think this long overdue creation of degrees of robbery, as we do in every other type of offense, and the fact that we have more people in prison on robbery than we do all drug charges, really is in no small part due to the degree of representation that the individual has as they are brought before the court on a charge of robbery. And those who aren't well represented may well find themselves number 2 rather than number 3. And those who are well represented may well have been involved with 3 and they really deserve 1. And I should stop now, but I'm going to say, actually deserve 4, excuse me. I'm also going to say, the reason I ask, what is a deadly weapon? I wanted to be responsible about number 3. And it appears many, many times in the code, and it's never defined. So it means that if you're trying, if this trial situation, such as I alluded to, is happening, how deadly weapon may have been regarded as to whether it's a penknife or it's a machete is something that, again, I think lends itself to reveal that would that everybody had the best possible defense and assistance in preparing their case.
Thank you, Delegate Watts. If there are no other questions from the committee operates by motion.
Move to report.
With
Substitute.
Amendment.
As amended.
All right, it's been moved and seconded to report as amended.
Madam Chair, speaking to the motion.
Delegate Williams.
I'm not going to vote. I'm voting no on this for one reason. This is complicated and I'm exhausted. So I'm going to vote no. And then we'll figure it out. We'll figure out what it does.
And this bill does not need to go, this is not on the list, Madam Chair, of bills that need to go to appropriations, correct? Okay, so we have a report with amendments. Moved and seconded. The clerk will open the roll. Watts is recorded as yes. Clerk will close the roll. The bill reports with amendment 5-3.